Good morning. Welcome to the Stringer LLP 39th Annual Conference. We are presenting this year from downtown Toronto. Today, we have a live audience with us. Most of you are attending remotely. I believe we have about 500 attendees joining us today. So welcome to everyone and people from across North America. First of all, I would like to acknowledge that Toronto is on the traditional territory of First Nations that include the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and Wendat peoples. And Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. In today's program, we will have breaks. You'll be happy to know there'll be a 15-minute break in the morning, a 15-minute break in the afternoon, and 1 hour at noon. We try to keep to our schedule as best we can. And if you have questions, hopefully you do, there will be Q&A sessions at the end of the morning and the afternoon sessions. If you're at home, type your questions into the system at the bottom of the Zoom page. You'll see a Q&A button. If you click on that, you should be able to enter your questions, and we will moderate the questions during the 30-minute Q&A period. For those of you who are here in person, we will hand around sheets for you to fill out to pose your questions. And of course, the added benefit of being here in person is you get to ask the questions during the breaks with us live. After the conference, for those attending remotely, we will be sending questionnaires with surveys, which are very important for us to work on and improve our conference every year. And once you complete the survey, you can download the slides from today's presentations. And for those of you who are HRPA members, this program is eligible for recertification. It's worth, I understand, 5.5 CPD hours. Also, for the lawyers in attendance, of course, you can use this program for CLE hours as well. In order to receive the HRPA certification, I understand you must be logged in through Zoom, either through your app, signed in, or on your browser. If you're connected through your browser, enter your name. And then that way, we have it in our record to send HRPA that you attended. And then also email us at events@Stringer LLP for the certification certificate. So I have that right, Jeremy? Yes. He's the expert on the HRPA certification. And speaking of Jeremy, he's actually your first speaker today. He will be speaking about protecting your organization from departing employees. Over to you, Jeremy.
Good morning, everyone. So my topic is one near and dear to my heart because, as some of you know, a few years back, the government of Ontario, in one of, at this point, we must be up to number 50 of the Working for Workers Act that nobody asked for. And this was a change that came that nobody asked for in Ontario. And for some reason, we decided that California was the model that we would follow. And we introduced something that I'll talk about in a few minutes, some changes to the Employment Standards Act, which restrict the employer's ability to restrain employee conduct after employment comes to an end with respect to competing. And competing is a loaded word, and I'll sort of explain what the ESA and the Ministry of Labor thinks that means and what that might mean going forward for all of us. As a result of it, a whole bunch of employees who previously could be constrained with certain requirements and with certain limits to what courts would enforce from competing and soliciting your customers and vendors post-employment, all of a sudden it was illegal to enter into an agreement with them, which would restrain that conduct. And so all of those agreements, which were entered into after that, became no longer enforceable. And that's not even taking into account the fact that all of us have employees who have access to significant internal information that you can't get out on the street, even if it's just the right person to contact at a customer. That can be enough inside information to help somebody compete with you, strip away your vendors. If they're familiar with your IP, if they're familiar with what's in development, if they're familiar with your leverage, if they're familiar with how much you're earning on a particular product, they're able to outcompete in a way that most employers would say is just not fair. And dealing with that situation is incredibly risky. It's very expensive. And the courts will generally err on the side of allowing the employees to go out and do what they need to do to earn a living, as opposed to protecting you, except in the clearest of cases. And so I don't know why the Ontario government implemented this change, but it has made our lives an awful lot more complicated. I am going to be providing a little bit of practical guidance on some things you might be able to do in certain circumstances. But unfortunately, in Ontario, not anywhere else in Canada, our hands are a little bit more tied behind our back than they were before. So post-employment vulnerabilities, we're talking about trade secrets, other kinds of confidential information, who your customers and clients and suppliers are, who the contacts are, how much they're charging you versus how much they're charging others, information about your personnel and business opportunities, or even if they're not in the pipeline, things you've learned about or they've learned about as a result of their position of trust within your organization. So the legal framework in terms of what we're going to talk about, there's legislation. So the Employment Standards Act in Ontario, and there's a similar statute in every province in Canada. There are implied restrictions. So these are things that are built into your employment agreement, whether you have one in writing or not. So that includes the duty of fidelity that an employee implicitly has, the duty of good faith. Now, that's not the duty of the utmost good faith. That's the fiduciary duty that only a fiduciary has. And we'll talk a little bit about the difference between the duty of good faith and the duty of utmost good faith if an employee is a fiduciary. The duty of confidence, meaning that if they have confidential information while they're your employee, they must maintain that confidentiality. But then there can be express restrictions. So you might have a confidentiality agreement. Most employers do these days. You might have non-competition, non-solicitation, or what are called hybrid agreements. And we'll talk a little bit about what these different terms mean. But essentially, non-competition means you can't go out there and compete with us, which includes working for a competitor or setting up shop as our competitor. Both of those would apply. Non-solicitation, as the name implies, includes going after our employees, our customers with whom you dealt while you were an employee. And so there's a difference between competition and solicitation, whereas solicitation is a much broader bucket. Competition allows an employee to go after your business in a much more targeted and aggressive way. And we'll talk about the way the courts treat these things. So again, this is the Working for Workers Act of 2021. I think we are now at about 7 or 8. They just keep coming out with these things. I don't know why Premier Ford thinks this is a great idea. Nobody asked for this. There were a number of consultations about the Working for Workers Act changes that came at various times to different parts of different legislation affecting employment. Nobody responded, we really need this. So I don't know where this came from, but the Act now says no employer shall enter into an employment contract that includes a non-compete agreement. And it defines a non-compete agreement as an agreement that prohibits the employee from engaging in any business, work, occupation, profession, projects, or other activity that is in competition with the employer's business. Now, before this legislation came out, what the courts said about non-solicit and non-compete was very different. So what they said was non-compete is essentially the whole basket, and non-solicit is a small subsegment of the activities, right? So you can do all the things that you can do if you're able to compete. You can use that whole basket, all the activities that would be in competition with your former employer. Solicitation means you have to go out there. There's an active initiation phase, right? So you're going after the people with whom you dealt. You're going after the customers that you know are the customers of your former employer. You reach out to them. They don't just respond to an ad that's in the newspaper or online. That's not solicitation if they come to you after you move to a new company. But if you pick up the phone and call the supplier that you used to deal with when you were employed over here, and you ask them to give you the same price or better price at your new employer, that is solicitation. Same goes for the customers that you used to deal with, okay? And so what the court said was, we're only going to allow non-competition agreements to survive where a non-solicitation agreement wasn't sufficient to protect the employer's legitimate interest, right? So we're not going to stop employees from getting a job. We like free and fair competition. We live in a capitalist democracy. We think that's a good thing. Competition is a good thing. But we're not going to allow employees who can pose a significant risk to your business if they're allowed to compete broadly from competing. But we are going to allow you to restrain them from soliciting. And so the vast majority of cases that predate this act held that you can have agreements with most employees, though not all, which restrain them from soliciting for a certain reasonable period of time, employees with whom they worked, customers with whom they dealt, suppliers that they had contact with, but that you couldn't prevent them from competing generally. You couldn't just stop them from getting a job in their town, okay? And so the definition in the Act doesn't carve out non-solicitation. It defines the whole basket as non-competition. It does not then say, but not if this activity is not solicitation. It doesn't define the carve out from the basket. So what we have is a situation where it's very likely through the non-compete prohibition in the Act, there is now not even the ability to have a non-solicitation agreement built into any agreement which postdates September 25th of 2021 as a result. And we'll talk a little bit about some of the carve-outs there. So that the category which are exempt by the Act are C-suite level executives. So in a smaller company, that might be harder to define, but essentially that person is your CEO. That person is your chief executive of some office. Otherwise, they cannot be exempted as a normal employee. One exception to that would be employees who become an employee after selling you their business. So even if they don't become the CFO, the CEO, or what have you after they sell their business to you, if the whole point of buying their business was to buy their business so that they can't just turn around the next day and use that entire business they just sold you, that whole book, and just go and set up a competing shop, that's an exception. And so one tool where it's appropriate and not engaged in bad faith and just sort of a farce, would be to have employees sell you their book of business upon becoming an employee. And the exception that is glaringly missing from this, and if anyone had actually bothered to talk to employers and their counsel before implementing this, they would have heard, A, we should be exempting non-solicitation from this. And they would have heard, B, that salespeople and people involved in marketing should be one of the carve-outs too, because their ability to take the business that they're building on your behalf, the contacts they've developed, the goodwill they've developed on your behalf, and then go and just start selling to those people at another company and take all that business away from you, that's not exempt from here. But most salespeople, especially experienced ones, they have a book of business. They have a number of, they have a name, they have a reputation. You can buy that book of business, pay them for that goodwill, and then you have purchased their business. And you can't make this just sort of a, we're buying your business for $1 and now you're our employee. I don't think the Ministry of Labor is going to take kindly to that. But if they legitimately have a book of business and you believe you need to protect yourself should they leave, one way to get yourself an exemption from this clause would be to literally have them sell you their business and then they become a salesperson within your organization. That's an option. I've helped some clients with that in appropriate circumstances. But again, I wouldn't use that for the guy selling radios on the floor of the Walmart. Okay. Non-competes, again, are unenforceable. by including this language, what the Ministry of Labor has done is very likely created a situation where if you try to implement a non-compete and then you try to enforce it after the fact, even if it is a non-solicit, you're going to hear from the other side that after October 25th of 2021, that entire clause is unenforceable, and then you'll have to fight about it. Now, it went all the way up to the Court of Appeal in 2022. The fact that this is not predate the implementation of the Working for Workers Act provision here. So if you have an agreement which predates, you're going to want to hold on to those. Okay. So a lot of people in this room, you're going to finish with the various presentations my colleagues give, and you're going to go back to your organization and you're going to redo all your contracts. You're going to improve everything, and you're going to send everybody a shiny new contract that is now enforceable and meets all the new compliance requirements and responds to all the case law that you're hearing about. Before you do that, give some thought to whether you have pre-existing non-solicitation or non-competition agreements, which were in your contracts before or which were signed before, and make sure that when you roll out your new contract, you preserve those old agreements. So you can say that those old documents that you signed, those no longer apply. This will be your new contract, except for the non-solicitation or non-competition agreement that you signed previously. And so that way you avoid the trap of improving your contracts for termination clause enforceability, but losing the protection that you could get back then with that employee if implemented properly, that you can no longer implement now. So even if the employee's been with you for 20 years and they had a non-solicitation agreement before, if they sign a new employment agreement today, that non-solicitation clause that you put in today's contract might be void. So you don't want to lose access to that agreement that you have back then. So what about our implied duties? The duty of fidelity and good faith. So there is a duty during employment not to compete, not to take the company's property or information to use that or give that to someone else for their benefit. You have to promote the employer's interests, not your own. It applies only during employment. And if it is breached, there may be substantial damages which are awarded. And I'll talk to you about the RBC case in a few moments. Now, there's also a duty of confidence. So the duty not to disclose or use confidential information. It's based on, again, this implied duty of loyalty and fidelity to the employer. It is indefinite, this duty. So even after employment, the duty to keep things that you learned, which are clearly confidential, in confidence, remains indefinitely. The problem is, what is confidentiality? What is confidential information? And what is actionable, and what can you do if that information is shared? So generally protected in that implied duty, it has to be valuable, has to be actual customer, employer, supplier information that's not available generally out there in the public, pricing and profit information. What's your leverage, right? Your business plans that are not announced publicly, current business opportunities and ones that are being explored. If you have proprietary methods, technology, and techniques, those might be protected. But what is not protected is what's publicly available. So methodology, technology, techniques, which become known to the industry, that's not going to be protected anymore. The employee's skills and know-how, even if developed as a result of working for you, they can take that with them. You're not allowed to compartmentalize their brain and prevent them from going out and working for another company, doing what you do with the information you've now trained them on how to do. So enforcement. It's difficult to prove a violation, right? Unless it's something very specific. How are you going to prove that the competitor gleaned that information from that employee and not from some other source? It's usually the beneficiary, that new employer, that is in possession of the proof you need, and it's very unlikely they're going to tell you. They're not going to be cooperative unless you sue them and the former employee. And then you're taking a risk that if you can't prove it, there could be substantial damages against you for the costs of that litigation and the motions that you bring. It can be difficult to distinguish know-how from confidential information and how it was disseminated. I've been involved in a number of cases where this is exactly the issue. Luckily, in some of those cases, the way we found out that the employee was competing or was using our IP, my client's IP, not my IP, I take it on personally, was because somebody whistle blew, right? So some customer that they were soliciting called us and said, hey, does Joey still work for you? No. Well, he just called me. He told me that, I can get a big deal on A, B, and C if I come and work with him at this other company. And then we start looking into how it goes. We start looking into their emails, and we find that the day before they left, they copied a whole bunch of files from directories they had no need for, and they brought them to their new job, right? And then we can deal with it that way. But sometimes it's really difficult to get that smoking gun. So implied fiduciary duties, this is something that's very different. So a fiduciary is someone who is in a significant position of trust. So your lawyer, your accountant, your doctor, they are fiduciaries, whether financial, legal, or for health. Okay. And for an employee to be a fiduciary, they need to be in that level of trust within your organization. Okay. So just because they can do damage, just because you think of them as very important, that doesn't make them a fiduciary. And in almost all cases, save and except for the most senior levels in your organization, you're not looking at a fiduciary. You might be looking at someone who's really important. You might be looking at someone who could do real damage on their way out. They might be imbued with an awful lot of trust and confidential information, but that just makes them an important person. It doesn't make them a fiduciary at law. And the reason it matters is fiduciaries have implied duties that survive implicitly after employment, even if you have nothing in writing. So to be a fiduciary, generally, executives, the most senior levels of management, you need to look at whether they can have a controlling interest in the business. They decide what opportunities you go after. They steer the ship. Okay. The ability to make effective policy, financial, operations level decisions. Okay. Now, just because you call someone a fiduciary in a contract, even if they agree that they're going to act as a fiduciary, that doesn't necessarily make them so. A fiduciary obligation, at least an implied one, is essentially a duty of fairness. Okay, it's not a contractual obligation; it's an implied duty that the courts impose on the people who hold those positions of the utmost trust. Okay. And so if you try to impose fiduciary duties on someone in a contractual form and they're not really a fiduciary, the court's going to look at whether it is reasonable for those duties to have been imposed. And if you try to impose those levels of responsibility and risk and potentially exposure for that person for violating those duties, you're going to find the court is very unwilling to have your janitor, sued for violating fiduciary duties because they clean the office that has the important files in it. Okay. I'm being reductive, but you get my point. Okay. So close relationships with customers, even exclusive relationships, may not create a fiduciary relationship. So if you think about a salesperson who has access to your margins, who knows who your customers are that they are servicing, who knows what markets you're going after and knows all of these plans, that access to that sensitive information and those sensitive contacts does not make them a fiduciary. And we'll talk about one of the cases where that played out. So implied restrictions for fiduciaries, same duties as normal employees during employment, but after employment ends as an implied duty. They can't breach confidentiality like everyone else. They can't solicit customers and employees for a reasonable period of time post-employment. And you're not imposing that duty by contract, so you're not violating the Employment Standards Act prohibition on non-competes or non-solicits or whatever that language is intended to mean. But that obligation applies to a fiduciary because of their position of trust within the organization. They're prohibited from taking corporate opportunities that they become aware of as a result of their work in your organization. So if they're aware that your organization has eyed a particular market for a particular reason, and that's not known generally in the marketplace, and then they leave and go and work for a direct competitor, and they help develop that opportunity for someone else, that might be a violation of their fiduciary duties. You might be able to sue them for doing so, but they can compete. So it's sort of an interesting, right, that they're not allowed to solicit your customers and your vendors to leave you, but if they will go and work for a competitor, they are allowed to work, and they are allowed the fiduciary duties, these implied duties, do not rise to the level of the full basket of non-competition. It just means they can't pick up the phone, call your customer and say, hey, I'm here now. You should leave them and come here. Express obligations are important, again, subject to the fact that most employees are not going to be found to be fiduciaries, and you need to do it in a way that doesn't conflict with the non-compete prohibition in the Employment Standards Act. But certainly for confidentiality provisions, knowing what is confidential and treating it as confidential, understood between the parties, makes it much easier to enforce after employment comes to an end, because there's no doubt the following things are the confidential things. And that is something the court can help you with. If you just cast the net too broadly, even in your written document, you're going to find that the court doesn't know what's confidential enough. They might say that's unduly broad, and then they may not enforce even when it is appropriate, because the whole clause might get struck down because the employee couldn't have reasonably known what was confidential and what wasn't. So common agreements, again, we've got confidentiality, protecting what are your clear proprietary interests. You want to restrict that list. The impulse is to cast a really broad net. The broader and less specific, the easier it is for an employee to assert that it's unknowable what it is that you're calling confidential information. Therefore, you're actually restricting by your agreement my ability to compete. So any activities, right? You can't restrict an employee in a non-compete from engaging in any activities. So there are a number of things in confidentiality agreements which are permissible, and those are not affected by this, but you want to avoid preventing an employee from using their know-how, right? You want to carve out as exceptions things that are known in or become public knowledge, save and except through the actions of that employee in violation of the agreement, for example. We've got non-competition, non-solicitation. We've spoken about that, but hybrid agreements might be a sort of a list. So you're allowed to go and get a job anywhere, but not at this list of competitors. So that is a non-solicit, non-competition hybrid agreement. The courts treat them as non-competes. So if it's a hybrid or it's clearly a non-compete, then it's going to be treated as if it's a non-compete. A non-solicit, it needs to be clear that it's about going after, being the initiating party as the former employee. So as a general rule, the courts, again, because we live in a liberal democracy, which is based on capitalism, our courts in Canada actually are more liberal and more capitalist than the courts in the United States, which I always, my American counterparts always find that ironic, because we're Canadians, we're all touchy-feely liberals. But I guess that's not the case in our courts when it comes to this particular framework. And our courts believe that employees should be able to go out and earn a living. Our courts are adamant that competition is a good thing for our marketplace. I don't think they're wrong about that. And unfortunately, what that means is, if the employer overreaches when they try to restrain an employee after employment, the courts will say that is an unreasonable restraint on trade. We're not going to enforce that. You've gone too far. You haven't sufficiently prevented their actions post-employment from spilling over into areas that you really have no legitimate interest in. And therefore, we're not going to enforce it. And so a restrictive covenant with non-compete or a non-solicitation agreement, especially a non-competition agreement, needs to be very carefully drafted. It needs to be unambiguous. If it can't be clearly discerned, or if there are words in there that make no sense or aren't lawful, then you're going to have a court saying, well, I can't interpret this. I'm not going to rewrite this based on what you meant to say. I'm just going to strike the whole thing down because I don't understand it. Neither can the employee, and that's unfair. You want to ensure it protects your legitimate proprietary interests. So you don't want to go after every employee for the same thing necessarily. You might want different levels of restriction for different levels of employees. What you need for people in one department, you don't necessarily need for employees in another. The duration has to be reasonable. What is a reasonable duration? Generally for non-solicits, you're talking about 12 months is sort of a standard length. Much longer than 12 months, you're looking at only very senior people, and typically not more than 18 months to 2 years non-solicit for very, very senior executives of an organization. Most employees, 6 to 12 months is the standard. for non-solicit. For non-competition, anything more than 6 months, you better have a good reason why you need more than 6 months. And the courts will put your feet to the fire on, in the market, in your sector, what is the common practice before they decide what is a reasonable scope. Is it a typical sales cycle that you're looking at? Is that the reason why you need 12 months is because, from initiation of a contract negotiation to closing is a roughly 12-month cycle. Therefore, we need to protect this employee, we need protection from this employee's post-employment conduct for 12 months to protect us for that cycle. If you just randomly say 12 months, what if the employee argues that it could have been less and that would have been enough? And if the court agrees, the whole thing goes away. The court just doesn't say, well, it would have been reasonable to do 10 months or 6 months. You did 12. The rest of your contract is good, so we'll enforce it, but only for 6 months. No, they'll just strike the whole contract. So they will use the rule of contra preferentum, which is that you're the employer, you drafted that agreement. If there's any way of reading this thing that reasonably reading it, that would render it unlawful in its scope, the whole thing goes away, and we're not going to save you. So even if you have a clause that says, that clause up there where we say these things, if you find that those things go too far, then we're inviting the court to rewrite the clause so that it says what we meant to say, that the court agrees is lawful, and enforce that. The courts will not do that. That's called blue pencil, an order for blue penciling your agreement. They'll just strike the whole contract down. So your documents need to be clear, unambiguous. They need to be reasonable in terms of the duration, reasonable in terms of the activities that are restricted, and especially for non-competition, reasonable in terms of scope. If you don't literally say geographically, these are the cities where this employee poses a risk, you're technically saying in Timbuktu, this employee cannot engage in the same activities that they engaged in with us here in Toronto. And unless that's a legitimate risk, you can't restrain someone globally from getting a job. Right? Your clause will get struck down. Your contract will be not enforced. Again, if a non-solicitation agreement would suffice, a non-compete is automatically struck down by the courts. So you need to, if you're going to use a non-competition agreement, you want to have a separate non-solicitation agreement, and you want to have a clause which separates them so that if one gets struck down, the other one can survive. A few decisions, I say recent, but ignore me. They're recent in my mind, okay? So in these particular cases, we're dealing with these concepts, and I think the courts in these went all the way up to the Court of Appeal or Supreme Court, so I like to rely on these ones when I explain the sort of facts underlying these various concepts, okay? So in the Stabler case, Mr. Allen and Pineapple sold commercial insurance. They had very close contact with employees. They knew everything. They knew where all the bodies were buried. They knew all the margins. They had all the contacts. HL Stabler controlled marketing, billing, client finances, and relationships with the insurance companies that were being sold through the brokerage. Okay. But these individuals, Mr. Allen and Pineapple, had developed a lot of these client relationships for the brokering, for the sale of this insurance. They resigned and they went and worked for a competitor. 118 clients left to go to their new employer within months. Okay. Their written employment agreement said for 2 years, they can't conduct business with any of the customers or clients that they worked with when they were back at HL Stabler. These agreements had 1.5 time commission earned liquidated damages clauses. So of course, HL Stabler thought, hey, great, we can earn time and a half for every hour billed to these guys. The court's going to award that back to us. They asserted these guys were fiduciaries because of their positions of trust and access. What does the courts find? Neither of these guys were fiduciaries. The clause did protect a book of business, which was a legitimate proprietary interest. And the clause's duration was 18 months to 3. It was 2 years. And typically in the insurance industry, 2-year non-competes is what people were putting in place. The trial court found this was a hybrid clause because it only prevented competition with respect to clients they had dealt with while they were there, as opposed to broadly. The liquidated damages clause, that's fine, even though they're not compensating you for damages. It's a good sort of way to prevent somebody from using your stuff and going after your people. It was reasonable, therefore, in the public interest. Clause was enforceable, and the new employer, here's the cherry on top, jointly and severally liable. Well, not so much. So we get to appeal. And again, neither of them are fiduciaries. Yes, it was reasonable to protect that book of business, but the duration, 2 years, there was no evidence that that was actually within the industry norm, or that whether it was an industry norm or not, that was a reasonable amount of time for employees to be prohibited from going to work for a competitor. The clause was not a hybrid clause sufficiently. It was effectively, because they were marketing to everybody, HL Stabler, that was effectively just a bucket of non-competition goods. Non-solicitation would have sufficed. You could have just had an agreement that they won't solicit on behalf of themselves or anyone else your customers. That would have been enough. And that on its own was enough to overturn the non-competition clause altogether, because a non-solicitation would have sufficed. And also, it lacked any reference to where they were restricted. So they could have gone to Timbuktu and sold insurance, and they would have been in violation of that agreement. Therefore, the agreement was overbroad. So that's an RBC Dominion Securities is a success story. Okay, so I like to cover this one. So this is a branch manager literally coordinated, this is sort of investment advisors, coordinated a mass exodus of 12 other investment advisors on his way out the door. And he and all these advisors went over to Merrill Lynch. And before they left, they copied all the contact information for clients. They brought with them reports that showed where these people were invested, what their preferences were, what they were thinking about in sort of client profile information. RBC managed to retain only 13.5% of the book of business that these people tried to take with them. So you imagine, put this in any dynamic, whether it's investment advisors or any company, how this would decimate an entire sector of your company. A whole department loses almost 90% of its business in a period of weeks. So RBC claimed all of its former employees breached fiduciary duties. So not just the head honcho who organized this exodus, but all 12 of his subordinates who left with him. They argued a breach of implied contractual term not to compete unfairly, this idea that somehow there was an implied obligation not to compete post-employment unfairly. They had failed to give reasonable notice of their resignations. So all of their contracts said you have to give 2 weeks or 4 weeks or whatever it was, or it didn't say anything, but the idea was they should be giving an amount of reasonable notice under the common law. And they had misused RBC's confidential information. They took RBC's stuff and they used it to compete against RBC. So RBC claimed that Merrill Lynch and one of its managers were also liable for inducing that breach of contract because they helped organize this exodus. This didn't happen as an accident. They talked to this manager. They helped him to coordinate the basic entire department from being disconnected over here and implanted over there, and all the business coming with it. RBC claimed all of its former employees, Merrill Lynch and its manager, were liable for the torts of conspiracy and conversion, basically stealing. Findings at trial. No one was a fiduciary. Yet again, even that manager who had access to all of this, not a fiduciary. All former employees were liable for the failure to give reasonable notice, because none of them, they should have given 2.5 weeks, and they were each given individual damages awards to pay. All former employees were liable jointly and severally, so that RBC could go after any of them or all of them, for all the profits lost during that 2.5 week period as a result of this unfair competition they had engaged in during that notice period. $250K was how that was quantified. The branch manager found liable for a breach of his implied duty of good faith, not as a fiduciary, so not the utmost good faith, just his duty of good faith to retain the staff. So he organized this exodus before he left. Had he done this after he left, then As a fiduciary, he would have been obliged not to go after his former employees that he had supervised. But not being a fiduciary, he may not have those implied obligations unless they're in a contract. The court found that because he organized this during his time as an employee, he violated his duty of fidelity, his duty of implied good faith. And that was a $1.48 million award, essentially offsetting a lot of those gains. If you do the math, 250K multiplied out to get you 1.48, a significant period of time was compensated there. All of them were found liable for conspiracy and conversion. Punitive damages awarded in $330,000, and Merrill Lynch was jointly and severally liable for another $250K. Now, on appeal, again, no one's a fiduciary. All the employees were liable for not giving the notice of resignation. All former employees were liable for the profits as a result of, quote, unfair competition. No, there's no such thing as a duty not to compete unfairly post-employment. And that's what the Court of Appeal made very clear. The duty to compete during employment does not extend, other than to fiduciaries, to post-employment conduct in an implied sense. Only if you have a written contract can you restrain post-employment activities if they're not a fiduciary. The branch manager was liable for his breach of the implied duty of good faith. $1.48 million was taken away. And that I've sort of laid out the test there. The defendant was liable for conspiracy and conversion. That was fine. Punitive damages award of $330,000, that was upheld. And Merrill Lynch was no longer liable, even though they were sort of the mastermind of this. Goes up to the Supreme Court of Canada. And this is sort of the final word. The $1.48 million trial award against that branch manager for his breach of duty of good faith was restored. So this is the good news story, that one line right there. When an employee is still yours and they, on their way out the door, take your stuff, organize an exodus of your people, start letting their customers know, hey, I'm going to be out of here. What do you say you and me do business, wink, wink, nudge, nudge, after I leave? That conduct is a violation of their duty of good faith, whether they're a fiduciary or not. In every case I have ever handled for any client that has ever called me, the employees don't leave and then spontaneously think about what they're going to do after they leave, right? They have a plan. They're stealing your documents. They're going into places in your systems that they shouldn't have access to. And all of that is with a view to competing against you after they leave. So you may not, especially after the changes in Ontario, be able to stop them contractually from doing things after they leave, other than violating your confidentiality, which, so if they take your stuff that's confidential, that's still a violation. But you can definitely go after them for the things they do and the things they take on their way out the door while they're still your employee. Chaffron and KRG I won't go into because that's sort of another version of the first one. So let me take you through some of the sort of overarching themes here, okay? Don't rely on implied duties, including fiduciary duties. Don't assume someone is a fiduciary just because they're senior. That is something that you're assuming. If they're a board member or they're your CEO, yes, there's no doubt they are a fiduciary. The content of those duties is generally the same. The duration of those duties might be different in different circumstances. So a fiduciary is restrained for a reasonable period of time post-employment from doing certain things. What's a reasonable period of time? You can't agree on it in writing. That's not sufficient because fiduciary duties are basically a basket of restraints that the court gets to decide. What was the reasonable amount of time? Was it 6 months? 6 months is typically the minimum amount of time that a fiduciary obligation might survive a resignation. But what about 12 months? What about 18 months? Perhaps the nature of what they're doing and the information they have means those obligations are indefinite because they can only access that opportunity with confidential information that nobody else has if they weren't there. So you're going to want to have a clear contract, which tells people what's confidential. You're going to want to have clear restrictions. You're going to want to preserve those agreements that you have pre-October of 2021. If they are not enforceable, still preserve them, but know that they're not likely to be enforced. You're You're going to want to make sure you have offer acceptance and consideration. So if somebody becomes an employee and 2 weeks later they sign that handbook that includes your non-solicitation agreement, where was the consideration? Where was the fresh something in exchange for their agreement to be bound by these very restrictive covenants post-employment? If you didn't give them something fresh and they didn't sign it with their contract, then it may not be enforceable when the time comes. Do review your agreements every once in a while to have a look at this. Certainly before you decide to enforce, call your lawyer. It can be extremely expensive if you have to enforce one of these agreements. I've been involved in a number of situations where we've had to go in without notice. You take a police officer with you and you take everybody's computers and their documents because you believe they've taken your stuff, they're using it, and they'll destroy the evidence if they know about your case before they receive the statement of claim. That's a $30,000 proposition, okay, just to get the ball rolling if you have to do something like that. So you want to make sure that you have them dead to rights, and you want to make sure you protect yourself before they leave, both from their access to things they shouldn't have access to, your ability to know if they've taken things that they shouldn't have taken, and then what you're going to do after they leave if you have to enforce. Thank you very much.
Thank you, Jeremy. Our next speaker is our associate, Sarah O'Flaherty, and she will be speaking about remote work, which I know is a big issue for a lot of you.
Hi, everyone. Thanks, Landon. Here it is. Okay. So my name's Sarah. I'm an associate here at Stringer, and today I'm going to be talking about remote work. So as you know, post the 2020 COVID era, work from home arrangements and expectations have really exploded. And for some employers, that work from home system works really well. But for others, there can be some headaches. They tend to face resistance when recalling employees back to the office. So today we're going to be talking about some key considerations around remote work and also how to lawfully mandate a return to office. So we'll be discussing WSIB, how to handle accommodation requests, how to enforce a camera on request, risks of constructive dismissal if we don't handle our recall right, and also how to mandate the return to office. So most of you are going to be familiar with the WSIB, but for those who aren't, the WSIB system is governed by the Workplace Safety and Insurance Act 1997. So the WSIB system provides compensation to workers who get injured in the course of their employment regardless of fault. To have access to a WSIB claim, the injury or illness has to have happened in the course of employment. So although there's no specific definition in the Act establishing what in the course of employment exactly means, the WSIB has published a policy called Accident in the Course of Employment that provides some clarification. So essentially, the determination of if an accident happened in the course of employment is made on a case-by-case contextual basis, depending on the surrounding circumstances relating to three factors: place, time, and activity. So when workers are in a fixed workplace, a personal injury accident occurring on the premises of that workplace is generally going to be considered to have occurred in the course of employment. Now, the WSIB considers remote work to include both temporary and permanent arrangements where the employer allows employees to perform their usual job duties at an approved location away from the regular workplace, such as working from home. So this means that work-related injuries that occur in an employee's home may be compensable under the WSIB. And it also means that reporting requirements for the employer are the same as if the injury occurred in a traditional work location, like on a plant floor or in your office. And we also note that when an employer is injured in the course of employment at home, the activity factor tends to be the key focus of the WSIB. But of course, place and time are considered as well. So many of the same injuries that could happen at your office, if they happen at home, can be covered by the WSIB. The WSIB considers the same criteria when determining eligibility. And the reporting rules are identical. So if your employee tells you that they were injured while working from home or offsite and required medical treatment beyond first aid, you must report to the WSIB. You also have to report if they didn't require medical treatment but were absent from work, earned less than regular pay, or required modified work at a regular pay for more than 7 calendar days. So again, you're not required to report a at-home work-related accident if the worker received only first aid, did not miss any time away from work, and did not require modified work. So many of the same injuries are covered, but there's also some gray areas. So clearly, if a worker is injured while working from home, taking out the trash or changing the laundry, this would not be covered by the WSIB. But there can be some kind of confusing gray areas. For instance, what if the worker is grabbing a coffee in their kitchen and they trip over a cord and they hurt themselves and get a concussion that way? So there's some gray areas here. The key point is if you're not sure if it's work-related, it's always safest to report. It's the WSIB's responsibility to determine the work-relatedness of a claim, and the possible work-related claim should always be reported. Now, there's other important considerations for remote work outside of Ontario. When an Ontario worker is temporarily outside of Ontario, the WSIB automatically covers them for 6 months. However, employers can request an extension for up to 3 years. There's a 1-800 number on the WSIB's website. You can call and request that extension. You should also remain aware of registration obligations. So for instance, if your worker permanently relocates from Ontario, let's say they move to BC, you have to register with WorkSafe BC and pay BC premiums for that employee. There are also key considerations that extend beyond the scope of workers' compensation that we won't get into today, but we wanted to flag. So there's tax law implications, of course, employment law obligations, and then immigration law considerations that you should be aware of. Even more considerations for the WSIB when somebody works from home. So you don't have as much control over your workplace when your employees work from home. So you can't control the environment, such as home maintenance, electrical safety, furniture stability, ergonomic workstations, things like clutter. So in my example where the employee trips over a printing cable. There's also blurred boundaries between work and personal time when employees work from home. And that can really create some ambiguity when the WSIB looks at the time factor. So, was the worker on a personal break when they were hurt, or were they working? There's also mental stress claims through the WSIB. And now that can be hard to monitor workers for when they work remotely. You're not able to necessarily tell if they might have some sort of psychosocial hazard or if they're being impacted. So it's just a consideration that employers unfortunately have less control over the workplace when their employees are working remotely. There's a number of measures you can take and best practices you can implement to protect yourself and your workplace. So the key ones I would say are establish clear working hours if possible. Not every position and job will have a clear-cut 9 to 5, but for the ones that do, it's good to have clear working hours. Establish break rules and a designated workspace, because without those clear boundaries, the WSIB could interpret ambiguous situations in the worker's favor. Best practices are things like implementing a formal remote work policy or having a remote work agreement with the employee who is working remotely. You can have a home hazard checklist. You can have ergonomic guidance on safe workstations and safe work setup. And you can have hazard reporting procedures even when an employee works at home. An important thing to make sure is that you are training your HR and your staff who deal with WSIB on remote incident reporting protocol. So as I said, the timelines are still the same as if your employee got hurt at the office. They're very tight timelines, 3 days. So you want to make sure everyone remains aware of these timelines and of their obligation to complete a Form 7. Again, documentation is your best friend. So document that you have this formal policy, that you have an agreement with your employee. Document that you've gone over ergonomic training with them. Documentation that there's a designated workspace can help. So document. And again, if you're not sure whether the accident is covered under WSIB, It's always best to report out of an abundance of caution, or you can contact a lawyer and seek their advice. But again, I emphasize that you should really act quickly here. Okay, moving on to accommodation requests. So again, since 2020, employers have become inundated with requests to work from home. Now, many of these requests are going to be preference-based, but there are going to be accommodation-based requests, and that distinction is very important. So as many of you will know, employers are prohibited from discriminating on protected grounds. And the two most common ones that are engaged when it comes to a work from home request are family status and disability. So human rights legislation requires accommodation to the point of undue hardship, which in simple terms involves making reasonable modification to workplace rules and practices to accommodate individuals with a disability or with protected needs. The duty to accommodate arises when the employer becomes aware or ought to become aware that an employee requires support. So a formal request isn't always necessary. You may have observable signs like consistent lateness, physical signs of discomfort. Sometimes an employee seems unkempt a lot. And that seeing those signs can trigger the obligation to inquire. So you have to assess the situation, and where appropriate, you actually have to take the first step to initiate that accommodation process. Now, employers have to demonstrate a good faith effort when assessing accommodation requests. There's both a procedural and a substantive aspect to this, and the procedure to assess the accommodation is as important as the substantive content of the accommodation itself. So while accommodation is mandatory, it is not unlimited in scope. Employers can refuse accommodation on the basis of undue hardship, which is evaluated based on cost, health and safety, and availability of external funding. Subjective factors like inconvenience or employer preference are not legally valid reasons for denying an accommodation request. It's important to remember also that the standard for accommodation is reasonable, not perfection. So again, accommodation is a collaborative process, and the employee must also actively participate in this process. So this includes providing documentation and information necessary to substantiate the accommodation request itself, and allowing the employer to access this information. So if faced with a disability request, employers can ask for medical documentation that outlines the nature of the restrictions and the limitations and how long those restrictions are expected to last. So we encourage you to ask questions about the work environment and what it is that's preventing them from performing their duties. You know, is it that they're sensitive to the lighting or particular sounds in the office? Is it some sort of ergonomic issue with the workspace? Are there mobility issues that maybe prevent them from working in the office? Now, when it comes to a family status request, you can again ask questions. So typically these fall under caregiving responsibilities, but not always. And ask questions like, what specifically needs to be accommodated? Is it a drop-off pickup time? Is it after school hours? You're allowed to figure out here what really the core of the request is. So to give you a very lawyer answer to can I deny a work from home request, the answer is it depends. So a request can be denied if it does not engage a protected ground. General requests based on, a general report of anxiety without medical substantiation is insufficient, as would an employee's general fear of contracting COVID or the flu or hantavirus. You can also deny a request to work from home if there are other reasonable means of accommodation available. So for my family status example, you can consider flexible stop-start times to accommodate school pickup needs instead of a blanket work from home. You also have to look at the core duties of the employee's position. So for some employees, their core duties just simply cannot be performed from home. And on that basis, you can deny the request and look at alternate accommodation options. So my example would be a dental hygienist cannot perform the core duties of their employment from home. There's a lot of best practices when it comes to work from home accommodation requests, but to go quickly, again, documentation is your friend. So you need to create and consistently enforce a policy. A written policy outlining the circumstances in which an employee may or may not work from home, the locations from which they can work, the details like how many days a week they can work from home, those are your friend. You have to enforce it consistently, although you have to remain aware of accommodation needs. So it should be enforced consistently across your workplace, with the exception of sometimes accommodation needs mean that somebody gets an exception. If accommodating a work from home request, ensure consistent documentation is occurring with respect to the request itself, the information you received in accordance with the request, all of the options that you considered, the reasons why you either granted or denied the request, and also document how it's going. So document any performance issues early. Moving on to camera on rules. A lot of employers have a lot of virtual meetings and often ask us, can we tell people to turn their cameras on? I know it's not very popular, especially like an 8:30 a.m. meeting, but the answer is that an employer, in short, can tell their employee to do just about anything within the general constraints of the employee's job description, provided that request is lawful and reasonable. So, of course, the cameras on request is lawful. The question becomes, is it reasonable for the employer to tell the employee to use a camera during their virtual meetings? The standard for reasonable is it connected to the job? Is it an arbitrary or disproportionate request? And does it reflect your legitimate business interests? So again, the duty to accommodate, which we're going to hear a lot about today, could be triggered. An employee could suggest to you that being on camera causes, let's say, debilitating anxiety, in which case, if they have a doctor's note to substantiate it, you would have to accommodate that request. But if not, it's a legitimate request that needs to be followed. And if an employee refuses to do so, they can be disciplined for insubordination. Moving on to constructive dismissal. So there's two types of constructive dismissal. One where the employer unilaterally makes a substantial change to a fundamental term of the employment contract, which is the one we're going to focus on here today. There's also a second type where the employer can create or permit a work environment that's intolerable or objectively unreasonable. But we're going to focus on the first branch today, which was the focus in Farber. Now, when an employee is faced with a potential constructive dismissal, there's three things that can happen. So first, the employee can accept the change in the terms of employment, either expressly or through implied, in which case the employment continues on the altered terms. Second, the employee can reject that change and they can say they've been constructively dismissed and commence a lawsuit. Third, the employee can make it clear that they are rejecting the new term, and the employer can respond to this rejection by terminating the employee, giving proper notice, and offering reemployment on the new terms. So if the employer does not take this course, however, and the employee continues to fulfill their job duties, the employee is then entitled to insist on adhering to the terms of the original contract. So there's a two-step test that the Supreme Court came up with in 2015 for determining whether a constructive dismissal has occurred. So one, you determine whether the employer has changed the contract unilaterally and detrimentally. Now, that determination also includes whether they have an implied or express right to make the change, which involves looking at the terms of the contract, or if the employee has consented or acquiesced to the change. We'll talk a bit more about acquiescence in a second. And if there was no breach, there's no constructive dismissal. Now, if there's no consent, you go to step two. So step two is a reasonable test. You would determine if a reasonable person in the same situation as the employee would feel that the essential terms of the contract have substantially changed. So acquiescence is basically silence. It's where you can infer permission or consent arising when the employee takes no steps and no action to basically disagree with the substantial change that has been presented to them. So there's a question, how long does the employee have to object to the change? A lot of cases have kind of considered this and looked at different factors. It's a very context-specific question. Things like accommodation can impact this time period. But in essence, the case law seems to point to a 6-month range. So the employee has a pretty good amount of time to make a decision whether they're going to object to a substantial change in their contract. There's a number of common examples of constructive dismissal. So significant reduction in compensation, typically more than about 15%. That's a constructive dismissal. Demotions are a constructive dismissal sometimes. A temporary layoff where there's no contractual right to a temporary layoff. And again, the workplace harassment and bullying, so that poisoned work environment, can also be a form of constructive dismissal. For our purposes today, there's also an intersection between constructive dismissal and return to office mandates. So since 2020, these work from home expectations have increased, and many workplaces still have remote or hybrid arrangements. What tends to have happened is that employers weren't very explicit that the work from home arrangements were simply temporary. And the time period that's elapsed means that a lot of employees have argued that remote work arrangements or hybrid work arrangements have become permanent given the passage of time. There's been a few cases that have discussed this, and interestingly, there was a case recently where an employee was allowed to work from Belgium for 2 years. She was an Ontario employee who worked remotely from Belgium. And then after about 20 months, her employer tried to recall her into the office. The court said that she'd been constructively dismissed because the remote work had become an accepted term of her employment. And the court emphasized that a recall to a physical workplace has to be timely and clearly communicated, especially where it's a core term of the employment relationship. So for Miss Bird in the Bird and Welcome Home Children's Residence case, she worked for almost 2 years. There were no issues with her remote work that the employer ever brought up. And then she received an order to come back to the office one day. So this case tells us that if there are issues arising from the work from home arrangement, it's important to document those and discuss those with the employee. And if there is going to be a recall, it has to be timely and clearly communicated. There was another case where a return to work mandate was a constructive dismissal after 20 years on a hybrid schedule. Now, this hybrid schedule had been agreed to orally, and the employee had been operating on the schedule for about 22 years. Now, the following a change of ownership in the company, the employee was told that she had to return to the office 5 days a week. So she resigned and sued for constructive dismissal. And the court found that the ability to work from home had become a fundamental term of her employment. And that revoking that term, or that arrangement, was a fundamental alteration to the contract. So she was found to be constructively dismissed. So what happens when your employee is found to be constructively dismissed? The damages for constructive dismissal are the same as wrongful dismissal damages, which common law notice. Now, common law notice is almost always more generous than contractually agreed to periods of notice in your employment contracts. So they can be quite a heavy burden on the employer. How do we avoid this? Well, how to effectively and lawfully mandate a return to office. First thing you want to do is check your employment contracts. Some important things to look for. 1, was the employee hired as a remote or hybrid employee? That's going to make things a little bit more complicated. If it says in their contract they're a remote employee, we have some considerations here. Number 2, is there a location at all that's discussed in the contract? Often you'll say you've been hired to work from this office or from this location. You want to check and see what that clause says. Similarly, is there language in the contract entitling the employer to change the location? This is an important one to look for. And if it's not currently in your contracts, when it comes time to update your contracts, you'll want to ask about that. So after you check your contracts, you're going to want to give timely and reasonable notice of the change. A few months is a good starting period, but it could be longer. And you'll want to consider, if possible, phasing the return. If you have a completely remote employee, instead of demanding 5 days in the office from the outset, you might consider a hybrid schedule for a few months. So they can go from remote to 4 days, after a month or so to 3 days. Phase it and see how that works. You also want to set very clear written in-office expectations. And again, you want to consistently enforce this across the workforce. You don't want this to be seen to be arbitrarily imposed on one employee or one group of employees. Again, you have to be aware of accommodation requests. So if you are doing an office-wide return to work office mandate, you are very likely going to be receiving accommodation requests. Each of these needs to be considered individually in the context of that request. And the mandate, although it needs to be consistently applied, again, it has to be subject to those accommodation requests. While an employee can refuse a lawful mandate to return to the office, they can be disciplined for this if there is no accommodation request present. Now, if an employee refuses your return to office mandate, you're going to want to ask questions. Why is it that they don't want to return to the office? What are the burdens in the way of them returning to the office? Now, again, the duty to accommodate could be triggered here when you ask these questions. So they might bring up childcare obligations. They might bring up a legitimate disability. Then we go back to our earlier slides on duty to accommodate. You're going to want to document these conversations. You're going to want to document the information you've received, and you'll make an individual plan with that employee. So finally, mitigating risk. Again, we encourage you to review your employment contracts before you make decisions about returning to office. Review termination clauses and see if there's any language allowing you to make fundamental changes. Listen to the employee concerns as they come to you. Respond to each of them individually. Always document these conversations. Again, giving appropriate notice of the change is really important. I would say at least a few months. Finally, if an employee alleges constructive dismissal, going back to what the court outlined in the Ronco decision, you can consider terminating the employee and offering reemployment in writing. So you can offer them employment on new terms, and the new terms here would include working from the office. Now, you've given them the proper notice, and you've offered them to work from the office. Now, if they say no, you can say, okay, well, you've been terminated, so thank you for your service. Or you can consider allowing them to work on the original terms. That will very likely present some problems for you, though, because, again, you want to implement these changes consistently across the workforce where possible. That's everything from me today. Thank you very much for your time.
Thank you, Sarah. Just to get it off my chest, I really hate the Ronco case. It's just like, to me, it's just one of the most ridiculous things the Court of Appeal ever did. And they've done some crazy things, but that's up there in their top 10. Respectfully, yeah. Our next speaker is my partner, Ryan Conlon. He's going to be scaring you about the activities from our Ministry of Labor in regard to health and safety enforcement.
Hello, and thank you for joining us both in person and virtually again this year. So yes, it is that time in the to address occupational health and safety, and in keeping with Jeremy's remarks this morning about ramping up enforcement and no one asking for things, and these ideas sort of coming out of I don't know about left field or right field, depending upon your perspective. But there is yet again from the Ministry of Labor a new enforcement system on the way. If you were here in previous years, you heard me speak about increased fines, higher maximum fines, and new sentencing criteria and such. But the party's not over as far as enforcement of health and safety goes. The Ministry of Labor has now introduced what are referred to as administrative monetary penalties. Some would say, what's the difference between that and a fine? Practically none. Legally, we'll explain there is a distinction. A fine's imposed by a court, whereas this is kind of like the difference. Like the old days, you could fight a parking ticket in court. Now you fight it with some municipal person. This is kind of that situation. There's also some new sentencing provisions that are out that I wanted to alert you to that really could ramp up the amount of fines that employers that have faced more than one conviction in a 2-year period for. Then I'm going to talk about some criminal cases. They're becoming more common. We're seeing more criminal prosecutions happen. So I wanted to go through some of the more recent and important criminal cases. And lastly, I'm going to talk about something that I'm asked about a lot, and something that my partner Jeremy and I have had some experience with this year is there any possibility of when an employer is being sentenced by the Ministry of Labor, if it's a corporation, to anything other than a fine? Obviously, if it's an individual, it's a fine or jail. But is there some other way? Is there a civil remedy, like Americans call it, or a deferred prosecution agreement, as it's referred to in the criminal context? So we'll talk about the courts and the ministry's take on those issues. All right. An administrative monetary penalty, which has the abbreviation AMP, is basically a financial penalty that an inspector can impose for any violation of the Occupational Health and Safety Act, regulations, orders, or requirements of an inspector. Well, what say you is the difference between this and a fine? Well, I mean, it's largely, a dollar is a dollar, right? Whether it's called a penalty or a fine, that aspect of it is obviously the same. But these penalties, it's the procedure that's in challenging them that's largely different. They're imposed outside the court process, so there's no, charter issues that arise. The issues of disclosure don't necessarily attract the same kind of constitutional scrutiny as a protection in court. And many of you may be saying, well, isn't this just a prosecution by another name? Well, I would agree with you. That's basically what it is. It's a prosecution without procedural protections. But what the courts have said is that these penalties attract less stigma than a fine. That if you go through court, a prosecution is considered by the community to be more serious than a so-called administrative proceeding. Which, of course, is if you're paying hundreds of thousands of dollars in an administrative penalty, I'm not sure that stigma makes a significant difference. But that is sort of where we're at in this new potential world of administrative monetary penalties. Administrative monetary penalties, there's precedent for it. They've been used in various provinces across the country. And most of them are for very minor things. They're the kind of penalties that are issued where a worker's not wearing a hard hat, or for not having a health and safety committee with sufficient training. Things that are more technical in nature, and they're usually relatively low dollar. The Ministry of Labor has historically issued what they called Part 1 tickets for these kind of offenses, usually in construction, and the maximum fine is $1,000 or less usually. So they're, similar to an administrative monetary penalty, but they're low dollars and they still went through the court process. You would still go to a provincial offences court to defend one of these tickets if it became of interest to you. The one province that's an exception, for those of you who have operations in British Columbia, that province administrative monetary penalties are handled by WorkSafe BC, which is their workers' compensation board. And in that province, AMPs are the primary method of enforcement. Prosecutions are not unheard of, but probably less than 0.5% of enforcement out there. And the penalties under the AMP system can be as high or higher than our fines, particularly for employers with multiple locations and large payrolls in British Columbia. But I don't think that system is coming to a theater near you in Ontario. There's no suggestion that the province is going to abandon their prosecution system to start doing what BC does and basically treat everything administratively. But we don't know. It's currently because part of this, as I mentioned at the outset, this is not one of these things where there was a lengthy consultation or activists from the union movement or the employer movement saying, hey, let's have these AMPs. It sort of just came out of left field without any significant discussion with players. I mean, it had been referenced in various government reports over the years, but wasn't really discussed as an idea as to what's behind it. What's even more bizarre is the first administrative penalty that's been published by the government in terms of its amount is only related to public sector entities that aren't accepting health and safety systems that are validated by the chief prevention officer. Wow, that sounds like really the most important thing in health and safety in Ontario, doesn't it? I mean, it's bizarre. Clearly, there is a group of people that were very, very aggravated by the lack of acceptance of certain health and safety systems. For those of you in constructions, I'm talking about CORE and some of the other sort of ISO and some of the other competing health and safety systems that are out there. But the penalty is harsh, though. The penalty is the lesser of $100,000 or 10% of the contract value. So for those of you who are in the municipal space, I encourage you to be very careful to ensure you're accepting all of these health and safety systems that have been validated by the chief prevention officer. The rest of you can wake up and not worry about that because it's a very, very specific and isolated issue. Again, but it sort of shows clearly that a very small invested interest must have pushed this forward, because it sort of seems not the first thing that would jump to my mind as someone that deals with health and safety every day is that particular issue. Administrative monetary penalties can be imposed against any party, not just employers or corporate employers. That can be imposed against supervisors and workers. Payment will generally be required within 45 days of issuance unless an appeal is commenced. Appeals are heard at the Ontario Labour Relations Board, the legal body, of course, that determines matters pertaining to unions and such, and also here's unfair labor practices, things like that. But also here's appeals under the Occupational Health and Safety Act. Also here's, along with labor arbitrators, reprisal complaints. So the board is used to hearing health and safety issues, but rarely dealing with. It's rare for the board to be dealing with penalties and fines. That's not the historic nature of the kind of dispute and adjudication that the OLRB has tremendous experience with. Interesting here is that unions are not automatically parties to an A&P appeal. Those of you who are unionized who've ever appealed an inspector's order will know that any of the unions that represent any of the workers are automatically parties. They're not here. So it's just the Ministry of Labor and the employer, or the party that had the fine issued. And watch how short the deadline is to appeal, 15 days. That's pretty tight. So if you ever get one of these, you really have to get your act together in terms of getting this filed quickly. That is one of the shorter deadlines known to labor legislation outside of the obviously short deadlines associated with union certification proceedings. On appeal, the board can confirm, vary, or set aside the penalty. So basically, it sits in the shoes of the inspector who issued it. They can either accept the penalty, they can lower it, or just set it aside. What is the most interesting aspect of this, though, and it remains unclear to me, is whether due diligence applies to an administrative penalty. Because prosecution 101 is this. Let's take a simple example. If a machine is not guarded, for example, and someone gets hurt, or even if they're not, the Ministry of Labor, all they have to prove in court is that the machine was unguarded. And most of the time they can do that because someone was injured, or they can take a photograph of the machine showing someone could access it. And then it would be up to the employer to say, well, we took all precautions reasonable to have a guard there. We had a guard there. Someone removed it. And so this shouldn't be our fault. It was an innocent breach. I don't know whether in an A&P that is it only just that the guard was gone? That's the end of the day, basically absolute liability, or can we have a reasonable precautions defense? The vast majority of provinces in Canada allow for something resembling an all reasonable precautions argument, or an officially induced error and an honest belief in a mistaken set of facts argument to defend an administrative penalty. I imagine that will be what the case is in Ontario, but I don't know. It may very well just be if something happens, that's it. The only question before the board is if it happened or not. And if that's the case, most of the time appeals are going to be more about the amount of the penalty as opposed to whether there is or isn't a penalty. That remains to be seen. There is a 1-year limitation period to issue an A&P. That is less than the limitation period for a prosecution, which is 2 years now. That changed a few years back. The ministry specifically says in the legislation they can use debt collectors to pursue penalty payments. Those same way municipalities use debt collectors to collect on parking tickets and other provincial offenses that are that go to the municipality under the laws it's currently structured. In the same manner that they can publicize fines, like if you go to their website, they'll say XYZ Corporation fine, say $250,000 for fatality, and then we'll set out the details of what happened and where it was and who the court was and such. They can publish the identities of the parties who have been subject to a penalty. If a penalty has been paid, then a charge cannot be laid for the same offense. So the idea is that you can't go to court for the same exact same manner that you've been subject to an administrative penalty. But as always with the Ministry of Labor, the devil's in the details, isn't it? And one of the details that jumps to my mind, let's go back to that machine guarding example. Let's just assume that we pleaded guilty to not have, or we paid a penalty for not having a guard. What if the ministry charged us with not properly training workers with respect to machine guarding? Could we then be fined for that? That's certainly not the spirit of the law, but on the face of it, it's possible. So it remains. It's arguably an abusive process if you're capturing, but the ministry is going to say, well, having the guard is one thing, training is another. So we have to be. So we can't be assured the way the law is currently written that you can't be charged for something similar, but it's certainly clear you can't be charged for the exact same thing that you were charged with, that you charged an administrative penalty for. It seems unlikely, as I said on the outset. I think prosecutions are going to continue. I think that's the culture of the Ministry of Labor, and there just hasn't been any detailed public suggestion that they're changing their positions. Courts have confirmed that even high administrative penalties are permitted. like I often wondered, like there was an argument I thought of, always trying to think of a way around these things, that this is just really effectively criminal law, that what they're doing is, basically trying to take away procedural safeguards and impose fines. Well, somebody else thought of that argument in a securities fraud case, a rather serious one, where from British Columbia, where the individual was subject to a $56 million administrative penalty, and the court rejected the argument I thought of. So I think it's safe to say that these penalties are constitutional, unfortunately. And I guess the biggest frustration I have is we have no comment for the Ministry of Labor whatsoever. All you're getting from me is what I can read from the legislation. Very little in the way of how they plan on enforcing these. But if you've met the Ministry of Labor inspectors, you know that once they have these tools, that might be the next thing. And I've certainly have heard from a vice chair of the Ontario Labour Relations Board that this is something they're considering in terms of getting vice chairs with more of a health and safety background to hear some of these things, because the majority of people that adjudicate cases from the Labour Board come from a more of a labor relations perspective, because that's 85% of what the board hears. All right, so that's administrative penalties. Let's get on to the other good news of the day, which is the new sentencing provisions. And this is something, again, that is sort of in the spirit of the Workers for Work, the various Workers for Workers Act, sort of showing a tough on employers' attitude. If an employer is convicted of a second OHSA offense within 2 years that causes a serious injury, the employer is subject to a minimum $500,000 fine. So and this provision came into effect on December 19th of 2024. So if you've had an accident that postdates that date and you're convicted of an offense within 2 years of that date, another one happens that's serious, you will be fined a minimum of $500,000, or no matter what an ordinary sentence would be. So this really, if you're facing a charge, and especially if you had a subsequent accident, or even if you hadn't, you have to carefully think about if you're contesting whether you want to plead guilty. If you have a defense, and I think it's going to increase litigation here, because employers that might have been otherwise just inclined to settle the case might think, I don't want to do that. This is a relatively mild case, or no matter what, we get an offense. And what's really tricky here is that it's the second offense that causes a serious injury. Arguably, even if your first offense wasn't a serious injury, it was a minor thing, these provisions could be triggered. So, and you could be fined $500,000. That, and I will comment, it doesn't seem that it's likely to be retroactive, that if any of the offenses predated December 19th of 2024, that these provisions would apply, but there's no court that's ruled on that. But the general presumption in law is that provisions don't have a retroactive effect unless they explicitly say so, especially in the sort of quasi-criminal context. But the other thing that's interesting is, what is a serious injury? Who knows? It's actually not defined by the legislation. I think it's safe to assume that all critical injuries, as defined by regulation, any other accident that requires hospitalization or significant lost time, will likely be considered serious. So, it seems it's not every accident causes what's considered serious, but this is where lawyers start getting out the dictionary as to what serious is or isn't. But I think it's just more of a common sense approach. I think they're just going to take a look. If someone went to the hospital, it's serious. If someone went to first aid, didn't seek medical attention, the kind of thing that doesn't trigger a board report, didn't require any accommodation, that's not going to be considered serious in all likelihood. Or if it's a fairly minor thing, I really think when you're talking about, there's going to be not too many no lost time accidents that are going to fit into this category, because it has to be it's not whether it's a high risk near miss, it's what actually happened. But, the Ministry of Labor has been known to be creative with some of their terms. So the employers just have to take this into account when you're determining whether to contest charges, particularly if it postdates December of 2024. It seems clear that this provision can be triggered even without the first conviction being a serious injury. So this could mean that you had a minor offense. Let's say you paid a $20,000 or $30,000 fine for a no accident case, and then you turn around and have a serious accident. The fine starts at $500,000. Which to this date, there are not that many fines that have been imposed in Ontario for $500,000. And the ones that have been are usually large corporations, repeat offenders. So this $500,000, that's a big deal. Because remember, the $500,000 fine, it has a 25% victim fine surcharge on top of it. So the real minimum fine is $6.25. That's what you're paying, which is rather high, which is a rather high penalty across Canada, especially given these aren't criminal prosecutions. So important thing to bear in mind. All right, the hits just keep on coming. What's going on with criminal cases in health and safety? Those of you who've been in around a while would remember that about 20 years ago, the criminal code was amended to make it easier to convict corporations of criminal offenses relating to workplace accidents. Contrary to all expectations, this didn't lead to a flood of criminal cases. In fact, many unions, particularly the steelworkers unions, were very vocal that the police were not enforcing these provisions aggressively in Ontario or elsewhere. And that's starting to change. We're seeing more criminal cases and more criminal investigations and more charges being laid. The most famous criminal case still remains the Christmas Eve swing stage incident in Toronto here, a northern part of the city where a number of workers were loaded on a swing stage meant for two, where these workers were on drugs. They were illegal immigrants, all kind. Their supervisor, or so-called supervisor, was sentenced to 3.5 years in prison for his failure to ensure that the fall protection rules required by law were enforced, and then to ensure that the swing stage was not overloaded. Ultimately, he was sentenced to 3.5 years in prison. He appealed, and the Court of Appeal stated that imprisonment was necessary in this type of case for deterrence purposes. So it seems safe to assume that individuals that are convicted of criminal offenses are going to do due time in jail. This was an interesting case. This is from New Brunswick on a municipal construction site, and the accused was a site supervisor. But it was a water treatment plant, so it was a pretty significant project. And tragically, a worker died when he was working in a confined space when a rubber plug that was holding back 32,000 liters of water was let go from its position, and the worker drowned. So this person was hired. This is not just someone who's like a low-level employee or just a frontline supervisor. This is someone who represented to his employer, that he was a fairly sophisticated actor and was capable of being in charge of a significant construction project, which obviously includes a very significant aspect of that job is ensuring health and safety, arguably the most important aspect of it. So the accused was charged with criminal negligence on the basis that he didn't follow any of the New Brunswick OHSA provisions related to confined space. Which they're very similar to Ontario. Confined space requires having a written confined space plan, certified workers, having very specific training, the whole bit. Like if you look at the confined space regulation, it's pretty detailed, and then the Brunswick one is pretty similar to the Ontario one. And the supervisor took his case to court and said, well, he blamed the boss. He said, well, no one trained me on supervising. No one gave me any training in confined space. So what was I supposed to do about it? And then the supervisor pointed the finger at various other people he felt, were more responsible for that person's death. And when you have a bad case, when you say, well, that guy was badder than I was, that usually means you're not going to win, in my experience. And there's no surprise here. The court was very impatient with this supervisor's argument. And remember the context, this is a fairly senior supervisor, but some of these comments, when I do health and safety training for supervisors, I almost always refer to this particular passage from the judgment of paragraph 137, 173, where the court says that every person, regardless of his or her professional training, is required to act in accordance with the standards of a reasonably prudent person in the same circumstances. And what does that mean? Well, the court held that a prudent supervisor, if you're going to hold yourself out as and be paid as a supervisor, you have to familiarize yourself with the legislative duties set out in the Act and the regulations. Familiarize yourself with the site plan and manufacturer's manual. Something that this, so the person who was in charge of the project testified he never actually read the site plan, which is unbelievable when you think about it, that he's the person responsible for enforcing it, and the manufacturer's manual associated with the equipment. I will say that it is a common question Ministry of Labor investigators ask after almost every accident: has the worker seen the manufacturer's manual? Invariably, the answer to that question is no. Probably don't even know where it is. So I encourage you to retain manufacturer's manuals and make sure workers have an opportunity and have, in fact, reviewed them. Or at minimum, have the safety warnings that are in them. Remember, they're written from a perspective of avoiding civil litigation in the U.S. Have at least that the worker is aware of what those safety warnings are. Because every time the ministry just seems to ask for that, and it just, when they say no, it just doesn't sound good to an inspector and certainly doesn't sound good to a court. So ultimately, in this instance, the court said that this individual, regardless of any negligence by his employer, who was also ultimately convicted of criminal negligence, you can't blame the boss. You have your own independent obligations when you're a supervisor, particularly a senior one. So you can't, the individual, and he was sentenced to prison, not surprisingly. One of the worst cases, and sets the high watermark for a sentence that's ever been imposed in a Canadian criminal case. This was a supervisor of a small truck company who, well, he called himself the supervisor. It appeared in evidence he had an ownership interest in the company, but didn't own it for various reasons related to his credit and other safety-related issues of his traffic record. But in any event, the deceased worker raised the safety issue about the mechanical thickness of the company truck. And the supervisor just said, look, man, it's okay. Just go on. The supervisor takes no action and the worker dies because of the deplorable condition of the tires. And we're not talking like, a little bit flat, like disastrous, according to the Crown's evidence at trial, which was uncontested, that the condition of the tires made a serious accident almost inevitable, regardless of the skill of the driver. The court, not surprisingly, found that any reasonable employer would have the vehicle checked by a mechanic. This was an egregious safety violation. I mean, pretty much common sense. And not surprisingly, this individual was sentenced to 5 years in prison, which is on the facts, I think, was utterly justified. And it's the kind of case that I think criminal prosecution ought to be used for. They ought to be relatively rare, because most of the cases I see, even serious ones, don't, in my view, amount to the serious wanton and reckless disregard that was present in the Gillies case. I mean, just refusing to have a mechanic check a vehicle when there was clearly going to be a problem and someone raises an issue is the definition of wanton and reckless. That's what the criminal code is for. I will say I've seen some cases pending out in British Columbia where there's been some prosecutions where I'm starting to wonder whether that line's been crossed. There was a recent case involving a trench collapse where an employer had relied on some engineering advice, obviously not good engineering advice because the trench collapsed, but ultimately they were convicted of criminal negligence. I question as to whether that's the kind of case the criminal code ought to be used for, in the sense that may be an OHS case. But when you have professional advice, albeit they had no reason to believe it wasn't accurate. This wasn't, someone they just found in the yellow pages, dating myself, I guess. But this was someone, that held themselves out and was truly a licensed engineer. I think that ought to be a mitigating factor, not just on sentence, but to the level of what is wanton and reckless. I understand that the decision is being appealed, and I hope successfully. Not to minimize the tragedy of it all, but certainly there should be some consideration to due diligence by an employer. All right. Last thing I want to talk about is creative sentencing for corporations. One thing that many employers find frustrating, when they're charged, they come to me, particularly American employers, and say, look, okay, we've made a mistake here, but we don't want a conviction on our record. Can we have some sort of quote unquote civil settlement? The way, you go take a wrongful dismissal case and the case goes away because you pay the worker X amount. They sign a provision, usually which includes a confidentiality agreement and, all the things that a normal civil dispute is resolved on, which is almost always money. Whereas in health and safety, there is just no way out of this civilly. We can't just make a donation to the Ministry of Labor's favorite charity. We can't agree to certain things that we're going to do to stop that. The ministry, we have, both Jeremy and I on more than one occasion, have approached the Ministry of Labor and said, look, maybe what about looking at this in this case where we have facts? And you know what? The ministry's basic reality, if they feel that the case has no merit, they're just going to withdraw it. And we've had some good fortune that way in the last year or so, and some good advocacy to get there. But there isn't an option in Ontario for a so-called creative sentencing. The Act itself only allows for fines for corporations. Some commentators and even judges have expressed concerns about this. I was involved in a recent fatality case where the judge expressed in private at the pretrial conference, why isn't there some of this compensation going to the family of this person? Why is all of this just going to go to the city of whatever and not to this person? And where's the victim in all this? And our answer was, well, that's what workers' comp is for. That's the system. They can't sue civilly most of the time for these kind of cases. They get workers' comp, and that's the law in Ontario. It's the law across Canada and has been for almost 100 years. But other provinces have, Alberta in particular, look at these things differently. Some provinces allow for charitable donations, the creation of prevention videos. One Ontario court, one particular justice of the peace, has thought about, what about having an embedded auditor at the employer's expense? Essentially, not that I'm saying that's a great idea, but why not have a third-party person auditing health and safety employer's expense, reporting back to the court? The Ministry of Labor has said, look, that we're the ones who are responsible for enforcing health and safety. We're not going to have private police enforcing that. We don't see, unlike in the criminal context where the probation office has a significant role in monitoring individuals that are sentenced to probation, often as an alternative to incarceration. They're not interested in creating that kind of a system where we already have a broadly powerful ministry that can enter a workplace at any time without notice or warrant, that there isn't a need, in their view, to have this sort of parallel system or to have the courts do anything other than collect fines. So, as I said, courts don't have the power to order compensation for the victims. I mean, I will pause and say I have seen several times in the last couple of years plaintiffs' attorneys in the personal injury context trying to get around the bar in the Workplace Safety and Insurance Act. There's a couple of ways they try and do that. One is they assert that the conduct of the employer was so extreme and that it was criminal that it takes it outside the workers' compensation system. They sometimes even try to rely on the dependence provisions of the Family Law Act, which basically allow a dependent to bring a claim for the loss of a loved one. I will say that all of those claims have been turned down by WSIB, which has the authority to say whether the bar on suing applies. Basically, they've held that Family Law Act cases are derivative in nature, which means if the worker can't bring a case, neither can the employer. So that there's not been a lot of luck for that. But if you ever do, arising out of a workplace accident, get a demand letter from a personal injury lawyer, you got to get it to your liability insurer right away. They're the ones that your CGL carrier will generally defend these things, and they will generally defend them on the basis that there's no jurisdiction to bring a lawsuit. I mean, there are a number of narrow exceptions that are out there. And I don't have time to speak to those, but the most common one, I guess, is if you're if you're in the public sector and there's an accident involving a private employer of a Schedule I private company, they can bring a right of action. But that's the most common one, but there aren't many. But the Ministry of Labor's basic argument is we don't want creative sentencing. So it does with this whole AMP scheme. I just sort of wondered whether the Ministry of Labor might be open to the idea of saying, hey, rather than a fine, let's pay an administrative penalty. I kind of doubt it, because I think the culture of where I think these things are going is that the AMPs are going to be for mostly minor things. But we did see with that one penalty that's out for that very odd public sector contracting thing was pretty high. So you never know. Certainly, I think it would be a welcome development if we could resolve some of these of the appropriate cases that where the employer has done wrong, but perhaps not wrong enough to justify the sanction of a court penalty. It might be a way of settling some of these cases is to agree to an administrative penalty, which, maybe it's going to be the same amount of fine, but maybe not have the same so-called stigma, if that exists. So that might be out there as a possibility of creative sentencing. But the Ministry of Labor has just been very aggressive. They believe that the penalties for employers should be fines, and that's how it goes. That's how it's been enforced, and that's how we've done it for 100 years. For 80 years, that's how we're going to do it now. The lack of evidence of the useful utility of regulatory penalties and improving health and safety rates seems to be lost. But that's my own editorial opinion. I always think there could have been maybe some room to explore some of these things, where at the same time preserving certain cases to be prosecuted with severe fines, and you obviously can't imprison a corporation, but there may be other steps that can be taken that are more useful than just paying a fine. And as certain unions say, maybe there is a place for the victims to have some role in that in terms of some sort of compensation above what the workers' compensation system allows them to get, which would be, it has the advantage of not requiring significant legal activity, but it has a disadvantage of not being as lucrative as a personal injury case would be if those kind of cases were allowed. Though, of course, the worker has to prove negligence in those cases. So I'd like to thank all of you so much for your attention, for all this great news about health and safety, and see you next year.
Thank you, Ryan. We're now going to take our break until 11. But before we do, just a couple of announcements for those of you attending remotely. We've sent an email out to everyone where you can download the materials. We've had a lot of questions about that, so there's a link on the email. And we've also had questions about the HRPA certification. To obtain your certification, send an email to events@stringerllp.com, and we will send you the certificate. All right, so we'll be back at 11 o'clock. Thank you. Okay, we're ready to start up again. Unfortunately, we had a few minutes over break, but gives everybody a chance to refill their coffee and answer those emails. Our next speaker is our associate Natalie Perez, formerly Caballero. And she will be speaking to us about recent legislative updates, including the latest Workers for Workers Act.
Okay, they're all so much taller than I am. Okay, so good morning, everyone. As Landon said, my name is Natalie Perez. I'm an associate here at Stringer, and today I'm going to be giving you an update on some of the recent changes in employment legislation across Ontario. I'm cognizant that besides the Q&A, I'm now the only thing standing between you and lunch, so I'm going to get right into it. So the pace of legislative reform has significantly accelerated in the last few years. And from the conversations that I'm having with my clients, a lot of them are finding it very difficult to keep up with the changes. There's always a new rule to be followed or a new policy that needs to be implemented. So I tried to include some of the major amendments that employers should know about. So here are the four main topics that I'm going to be going over today. So the first one, we're going to talk about transparency in pay and hiring, expanded leaves, worker protections, and finally, mass terminations and layoffs. And that's where a lot of the big changes are actually happening. Okay, so first we're going to discuss transparency in pay and hiring. So in Ontario, the push for transparency in pay and hiring, I feel like I've said that 100 times already, is being driven by the Working for Workers 4 Act, which came into effect as of January 1st, 2026. And there are some quite exhaustive changes. I've listed them on the slide that's showing right now, but I am going to go through each of them. So the first major change has to do with job postings. And as of January 1st, 2026, all employers that have 25 or more employees are now required to disclose the expected compensation or range of compensation for a job. However, it has to be a publicly advertised job posting. So I'm talking about if you're using a website like Indeed or LinkedIn Jobs. However, if you just have a help wanted sign on your door, it does not apply to that. So you will be able to either provide an actual hard figure of how much you expect the compensation to be, or you can provide a compensation range. However, if you do choose to provide a range, that range cannot exceed $50,000 unless the position pays more than $200,000 a year. So what that means is if the position is paying in between $100,000 and $150,000, that's an allowable range, but you can't exceed that. However, something that is quite interesting and maybe a bit obvious to some is you're not actually tied to that range when you decide to hire someone. No one's necessarily going to be holding you to that number. But I, of course, would suggest that you try to be as accurate as possible, which is why they do give you quite a bit of leeway with the $50,000. So there is an exception if the company has an internal posting system that only your internal employees or previous employees are able to see. This range and salary disclosure element does not apply. So job postings also have to state quite clearly whether the position is for an existing vacancy or in the alternative, if you're hiring a candidate to fill a candidate pool or in anticipation of future growth. So you have to specify that it's not for an existing vacancy. Of course, the purpose of this is to prevent ghost jobs, specifically when an applicant applies to a job, they never hear back from anyone, and they're kind of left in the dark. Another important piece, if you're using artificial intelligence to screen, assess, or select candidates, you have to specify so in the job posting. As of right now, because this is fairly new, at least when it has been implemented in January, there hasn't been any guidance yet on what artificial intelligence means. So we have to look at I guess, a common sense approach. So for instance, if you're screening for certain keywords with AI, or if AI is marking individuals' interviews, that's something that you might want to specify. I would suggest that we err on the side of caution and indicate exactly what kind of AI we're using and how it's being used. Finally, employers will no longer be allowed to require Canadian experience in job postings in an effort to reduce barriers for internationally trained workers. So you may also be wondering what happens if we're non-compliant. So that would just be the regular non-compliance fines, and that can be up to $100,000 and more for appeal offenses or offenders. Okay, so the second step in these transparency rules deals with what happens after you've interviewed a candidate. If you conduct a formal interview, and I'm not talking about just a phone screen, but you actually call somebody in and interview them, the employer now has a legal duty to notify the candidate within 45 days whether or not a hiring decision has been made. So this is meant to address a common frustration, again, where an individual goes through potentially multiple rounds of interviews and they never hear back from the employer. There's also a requirement to keep records of whether or not these communications are going outwards, and you have to keep those records for up to 3 years. So it might be a good idea to have some kind of an automated system set up that that some kind of a notification gets sent out to interviewees, letting them know whether or not a hiring decision has been made. Next, we have employment information requirements. So we can put this in order. You posted the job, you interviewed a candidate, and you've made your decision. So starting July 1st, 2025, employees with 25 or more employees must give new hires in writing before their first day quite a few elements. They're listed here on the slideshow in the bullet points, and this is in addition to their employment contract. So think of this as a baseline level of disclosure that the government wants every employee to know. So they want them to know, where they're going to be working, who they're working for, who their employer is, when they're going to get paid, and how. So something that I've been doing with my, I almost said employees. I don't have any employees. With my clients, I've been implementing all of these details within their employment contracts so we can kind of kill two birds with one stone. So that might be something to keep in mind going forward when you're reviewing your contracts. Try to make sure that these elements are already included in there and give it to the potential employee in advance of their first day of work. Okay, finally is a record keeping requirement. So this last piece is the record keeping. So employers will now be required to keep copies of every publicly advertised position for 3 years, as well as that record of communication that I've already spoken about for 3 years as well. Okay, so now I'm going to move on to expanded leaves. Specifically, I'm going to talk about the new long-term illness leave, which came into effect on June 19th, 2025. So it is quite recent. So later on, I'm also going to talk about the new job-seeking leave, but I decided to put that at the end with mass termination. I think it makes more sense there, but there will be another expanded leave we're going to talk about. So in this case, if an employee has at least 13 weeks of service with your company, they can now take up to 27 weeks of unpaid job protected leave in a 52-week period where they cannot work due to a serious medical condition. In order to qualify, the employee does have to obtain a certificate from a qualified health practitioner, and that has been defined as a physician, registered nurse, or a psychologist. And that has to confirm that the serious medical condition exists, and it also has to specify the expected duration of the leave. So the statute does not actually define what a serious medical illness is. So I did try to look into case law while I was preparing these slides, but no cases have come out to date interpreting this. So as of today, it's a bit up in the air. But based on parallel ESA leaves, it's very likely to cover illnesses such as cancer, major cardiac events, significant mental health disorders. It doesn't seem the purpose of it, at least, does not seem to be covering colds or minor injuries. I believe it's intended for substantial impairments that require a bit of a substantial leave. So the purpose of this new leave is to fill gaps in the ESA. Employees previously only had access to 3 unpaid sick days for their own illnesses. Now the ESA entitlement aligns more closely with the EI sickness benefit entitlement, which is also up to 26 weeks. And hopefully no one has to use this for the hantavirus. Okay. So now we're going to talk about worker protections that have been expanded. So Ryan already touched on some of my topic, and he did it in quite a bit more detail than I did. So I would suggest that you look at both slides in tandem. So the first set of changes are to Ontario's Occupational Health and Safety Act. These changes took effect on November 27, 2025, which is the day the Working for Workers 7 Act received royal assent. Sorry, it's a tongue twister when you say it 100 times. So there are 2 things that I wanted to flag. First is the new defibrillator program. So certain workplace, which the law calls prescribed workplaces, will have to install defibrillators. So the act itself doesn't actually tell us which workplaces those are. That's actually set out in the regulations. Specifically, we have Ontario Regulation 213-91, which was amended very recently on January 1st, 2026, to mandate defibrillators on construction sites that regularly employ 25 or more workers and are expected to last 3 months or longer. So the WSIB will reimburse any employers that are required to have the defibrillator on board, but the decision on that eligibility, it's final and it could not be amended. Second, the Act gives inspectors new tools, and this is exactly what Ryan had previously spoken about, and that is administrative penalties. So inspectors will now be able to issue monetary fines directly on the spot for any health and safety violations. So once the fine is paid, that should be the end of the matter, and they cannot be charged for the exact same offense. However, if it isn't paid, it then becomes a debt to the Crown, and the ministry can even publish penalty information online, making it public for everyone to see. So overall, enforcement under the OSHA is definitely shifting. Inspectors used to only have the ability to issue compliance orders, stop work orders, or launch prosecutions. This is a bit of a middle bucket alternative to prosecution, so we can probably expect to see this implemented more often. So now we're going to move over to the Workplace Safety and Insurance Act. And these changes come out of the Working for Workers 7 Act as well. And there are 3 larger ones that I think you should know about. First has to do with false or misleading statements. So employers are now prohibited from giving the WSIB false information about a worker's claim. And if they do, the board can now issue an administrative penalty on top of any court fines. So an example of this, if an employer were to downplay the seriousness of a worker's injuries, potentially in an attempt to lower their WSIB premiums, that could now result in both a penalty and a prosecution. Second, we're going to talk about repeat offenses. So this is where the fines really do start to add up. If an individual is convicted of 2 or more counts of the same offense in one proceeding, the court can now fine them up to $750,000 per conviction. So as an example, if a payroll manager failed to pay WSIB premiums for 3 consecutive years and the court convicted them on 3 counts in one trial, this would mean that the maximum fine wouldn't be $750,000 total. It would be $750,000 per count. So that's quite large. Obviously, this is a very extreme example, but the potential liability could be a $2.25 million fine. And third is aggravating factors. So courts are now required to consider things like prior convictions, multiple offenses, or a documented history of noncompliance when setting penalties. So if an employer has a track record of ignoring the law when it comes to health and safety, judges will be expected to impose harsher fines. Okay, so now I want to cover a new protected leave that will apply during mass layoffs. This is very recent and it's very important to know about. So as of November 27, 2025, so this one has to do with the job seeking leave that I was talking about. It came into effect under the Working for Workers 7 Act, and it applies in cases of mass termination. So a mass termination is defined as when 50 or more employees are terminated within a 4-week period at an establishment. So in those circumstances, each affected employee would be entitled to 3 days of unpaid job protected leave in order for them to attend interviews, job fairs, or otherwise prepare for reemployment. So there are a couple of practical points with this. Employees should definitely give at least 3 days notice if possible, but verbal notice is enough. However, the Act does indicate that the inability to provide that 3-day notice does not disentitle them to the leave. Also, the leave can be taken in part days or full days. So if an employee were to take the afternoon off for an interview, but then, of course, they already work the morning, the employer is able to count that as a full day from one of the 3. However, the employee, of course, still has to be paid for the hours that they actually did work. There is an exception, however, and that's specifically where the employer gives mostly termination pay instead of pay in lieu of notice. No, sorry. If they give termination pay instead of working notice. I misspoke there. So the easiest way to understand the exception is this. So job seeking leave is mainly for employees who are still actually working during their notice period, and they don't have the ability to go and attend interviews because they still have to go to work. So if the employer pays them out and only gives them a very short working notice period, specifically the magic number is 25% or less of the notice period, then the employee is not entitled to the job seeking leave. So an example of how this would work, if the employer was required to give 8 weeks for a mass termination notice, right? So that would be if you're laying off 50 to 199 individuals. If you're terminating 50 to 199 individuals, you would have to give 8 weeks notice, of course. But if you were to only give 2 weeks of actual working notice and pay out the remaining 6, the employee would not be entitled to take these 3 days of job seeking leave because they have the ability to do so when they're not working. And in terms of verifying, the employer can verify the leave and whether or not the individual actually has an interview. But of course, it has to be reasonable based on the situation. So they might be able to send you, an email inviting them to an interview, whatever you feel is appropriate in the situation, and if it's even necessary. Okay, finally, the last thing I want to speak about is the new temporary layoff side of the Working for Workers 7 Act. So this is very important because layoffs can very easily go south very quickly, and the stakes are usually very high. So usually if an employer doesn't recall an employee before a layoff becomes a permanent layoff, an employee will likely be entitled to termination, common law notice, potentially severance. So we want to make sure that we're doing things properly. So before Bill 30, the ESA rules were fairly strict. Generally, a temporary layoff could last up to 13 weeks in a 20-week period. That was the baseline. However, in some limited circumstances, employers were able to extend the layoff, commonly up to 35 weeks, specifically where the employer were to continue paying the employees benefits or giving them some other kind of significant benefit or monetary amount. And those rules do still exist, but Bill 30 does not erase the old temporary layoff rules. What it does, it actually creates an additional pathway for employers to implement an even longer temporary layoff, but only where both the employer and the employee want to do so. So under the new framework, an employer and an employee can agree to an extended temporary layoff lasting 35 or more weeks in a 52-week period, so long as the layoff does not exceed 52 weeks in any 78-week period. So it doesn't have to be consecutive. But the important part is the employer does not just get to announce this unilaterally like it would be able to do in the other circumstances under the Act. So there's several hoops that you would have to jump through. First, there has to be a written agreement to do so with the employee. Second, before the agreement is made, the employer has to let the employee know that once they enter this agreement, they can't get out of it. And you have to do that explicitly. Third, you have to tell the employee the latest day that the employer intends to recall them back to work. And fourth, even after the employee agrees, that's not enough. The employer still has to apply to the Director of Employment Standards for approval in a form approved by same. The form is already up on the Ministry of Labor's website, and it's fairly short and simple to fill out. In terms of record keeping, employers must retain extended layoff agreements for 3 years after they receive approval from the director. So for small employers, this is certainly not just paperwork for the sake of paperwork. And honestly, even for large employers, missing a step can definitely be the difference between laying someone off and terminating them. Okay, so what does all of this mean for employers in practice? Obviously, there's a lot of new responsibilities, and as well as the ability to restructure your workplace in new ways, specifically through extended layoffs. And as you can see from the image on the slide, Ontario has been on a bit of a roll. The Working for Workers Acts, they're starting to feel like a Netflix series, one that just keeps on coming out with new series and spins, despite everybody telling them to stop producing the show. So the point is, these acts, they're going to keep coming year after year, and each one, it makes incremental changes that cumulatively adds up to a lot of requirements for an employer. So what can you do as an employer to make sure that you're staying on top of things? One is make sure that you're doing an audit of your compliance with the ESA, the OSHA, the Workplace Safety and Insurance Act. And I was just doing that at least annually. And if you don't want to do it, you can let your legal counsel know, and we would be happy to do so for you. Make sure that you're keeping policies current and that you're communicating them with your employees. If you want to rely on, for instance, an employee who's not listening or following a policy, they're going to have to see the policy, or at least sign off that they've seen the policy. Document leave requests, inspector communications, job postings, everything. There's no such thing as too much documentation, in my opinion. And make sure that you're training your managers and HR teams on the new obligations. So coming to conferences like this is a great way to do that. And above all, I would say keep monitoring for the next Working for Workers Act, because the chances are it's already being drafted. Okay, thank you, everyone.
Thank you, Natalie. So now we're at the Q&A session. I'd like to ask Ryan and Sarah to come up to the front table.
Let them know. In their binders, there's the Q&A sheets for the morning.
Okay. Apparently the Q&A sheets for the morning are in your binders for those of us who are attending live. And for those of you attending remotely,
The blue is for morning.
by the way, the blue form is for the morning, apparently. And Rita will be collecting those questions. So we have some questions to get us started. Jeremy, you'll recall Jeremy spoke about protecting yourself from departing employees. We have an employee who won't return company property, namely a laptop. What can we do? Can we call the police?
Well, that wouldn't be your first step. So the property is yours, but it came into their possession and control at a time when they were authorized to have possession or control. It's just that they're no longer authorized. So if they're refusing because they're ignoring you, that's different than they're refusing because they say it's theirs now. Touch it, now it's mine. So you would send them initially friendly and diplomatic, a nice email or a couriered letter, some way where you can verify they've received your message, which says, we need you to arrange to return this, give them the contact information for the person who will return it, and offer to send a courier to pick it up so they don't have to do anything. They don't have to lift a finger other than opening up the door and handing in their device to the courier. If they out and out refuse, at that point, I would say, either you return it by X date or we're going to call the police if that is the option you choose to take. The simpler way to do it, though, would be to send them a demand letter from your counsel, which we'd be happy to draft. It takes a couple of minutes, where we essentially say, we're going to sue you if you don't return this, right? So we don't want to promise, we don't want to threaten that we're going to call the police. We want to just do it. But we can certainly threaten civil legal action. And if there is something on that laptop that you need immediately, so there's data that is for existing customers and things like that, you want to bring that to their attention. In that letter, you can say, we need copies of those reports you were working on, which are only on your laptop, and we won't hesitate to sue you for damages if our customers are prejudiced or if our business is harmed as a result. If they still don't do it, at that point, the police may or may not be willing to sort of barge into someone's house to pick it up for you anyways, but you will want to file that report and get your counsel involved. I've never had a situation where someone refused to the point where we had to take any of those actual final steps. More common is where the employee completely deletes all the contents of the files before returning this thing to you. And that's an entirely different story, though.
Thanks, Jeremy. Ryan, here's a question for you. Is the Occupational Health and Safety Act AMP process live right now and being applied in practice?
Yes, it is live right now. The regulations have come into force. In practice, I'm not aware of any AMPs that have currently been issued. The rules of procedure have been drafted at the Ontario Labour Relations Board dealing with appeals, but as it currently stands, the only penalty that could be issues related to that obscure public sector procurement issue that I referenced in my presentation.
Great. Natalie, I've had a couple questions on the salary disclosure requirements for jobs that have a compensation over $200,000. So if the comp is over 200K, is the employer actually required to disclose the compensation range, or does it just mean the range can exceed $50,000?
Yeah, no. So it means that they're exempt. They do not have to comply with the salary posting requirements or disclosure of same if the range exceeds $200,000.
Great.
Okay. And Landon, I also have another question that was aimed to me. I can go ahead and answer it. So the question was, can we still ask or require that a candidate be eligible to work in Canada in job ads? And the answer is absolutely. So in regards to Canadian experience, that doesn't mean eligibility to work in Canada. It only means that you can't require them to have Canadian education, or you can't require them to only have work experience in Canada and not look at their experience that they have from abroad. But absolutely, they still need to be eligible to work in Canada, and you can indicate so in the job ad.
Sarah, question for you about requests to work from home based on family status. Can an employer factor in whether there is a spouse at home and if the duties are not divided 50-50 with the spouse?
Well, I think that I think that the question is not so much can you, but should you? And my answer would be, although it's a contextual approach when you're assessing accommodations, which can include a consideration of the supports available to the employee, you should be very, very careful about denying an accommodation request on the basis of the employee's spouse or partner. And what was the other one? Sorry.
Well, I think it was all kind of tied in.
Okay.
Yeah. I mean, well, I'll just say too that the whole area of family status accommodation is very gray legally. And there's not a lot of case law out there in terms of remote work and family status accommodation and all that. We actually have a case headed to trial on just that very issue. So maybe we'll make a bit of law on that. But my personal take on it is the request to work from home based on family status must be very well established, very well substantiated. Like someone doesn't have the right to work from home just because it would make their life easier or that would be their preference. Like there has to be very strong reasons for it. And I think in the great majority of cases, the individual won't be able to establish that they should be allowed to work remotely on that basis. But it very much depends on a fact by fact situation analysis. Okay, Jeremy, is a standard non-solicitation covenant okay to use for all employees, or should we have different non-solicitation covenants for each employee or for different roles or departments? In other words, can we do the one size fits all, or should they be tailored to individuals?
Well, I guess what I'll say is that although it's not the question, a non-compete should almost never be used unless you're dealing with very specific people and you've decided it's a good idea to do it, in part because when they challenge it, you're going to be subject to significant legal fees if you intentionally implemented a non-compete that you should have known was never going to be enforceable. A non-solicit, as I discussed in Ontario, may be problematic even if it is truly a non-solicit and has no non-competition aspects to it. So something we often do in our agreements is to hedge against this risk. We will have a provision in Ontario after the non-solicit, which is properly worded, which says something like, nothing in this agreement shall prohibit the employee from, and then we paste in the definition of non-compete from the ESA. So if anything has survived the ESA amendment, which prohibits non-competes in terms of non-solicit aspects, which might have survived that amendment, that should help you to allow that to survive. But again, query whether a non-solicit will survive at all, no matter how you word it, no matter which employees receive it or how it's formed. So I think that's a really important caveat. All of your hard work might be for naught. That said, I think senior staff should have a non-solicit that's more tailored to the actual risk. I think your janitor really doesn't need a non-solicit. I think that is offensive. And I think if you try to enforce that in a court, you are going to have, you could have an employee sue you for wrongful dismissal damages and assert that you inserting a non-solicitation clause made it harder for them to find a job. And then the court might award longer notice than might otherwise have been the case because you tried to implement an agreement that was really not necessary in the circumstances.
Actually, Jeremy, since we have you right here, we have a follow-up question on the laptop question.
Sure.
What if the laptop is returned, is intentionally damaged beyond repair or use, or the employee has wiped clean confidential proprietary information?
Sure. So both of those situations arise all the time. If you are providing electronic resources to an employee, you should have a policy on electronic devices and resources, and it should state explicitly that they are to take reasonable care and that if they damage these devices, they could be held responsible. An employee who had a perfectly good computer while they were employed, whose computer is now completely destroyed, I mean, that suggests actual destruction of property. You can sue them for that if it's worth it. Although unless their laptop is really expensive, that may not be worth the lawsuit that you're going to bring, up to you. On the other hand, if they have wiped out important information, number one, your policy should stipulate And your contract should stipulate upon the end of their employment, they must return all their electronic devices without deleting anything. And I like to put in those policies that if they have any personal documents or information, and I repeat this in the termination letter, if they have any personal data and they want removed, they should not remove it. They should let us know, and we'll facilitate a return of that personal data on like a USB stick or something like that. And we stipulate that we will go after them if they destroy the data on the device. Ultimately, unfortunately, if they take the step of destroying that data, there may be no way to reconstitute it. So if the harm caused by that deletion is significant, you might have to sue them for the actual loss of that. If it's the only copy of that data, it becomes very complicated and quite expensive. So, do what you can to ensure while they're still employed, the data is being backed up, you still have access, and that they've signed policies and they understand their obligations when their employment comes to an end.
And I'll just add on to what Jeremy was saying, because this can happen a lot where you suspect the employee has downloaded proprietary confidential information and kept it to maybe use to compete against you. If you suspect any of that, then first of all, keep the laptop safe. And there are forensic IT experts out there.
That's a good point. Yep.
Yeah, who can make a mirror image of the hard drive and conduct an analysis of the hard drive and find out. Quite often they can reconstruct when the data was taken, where they saved it. If they attached a thumb drive and say downloaded a bunch of customer sales spreadsheets or things like that, you can actually establish that and then sue them for it and maybe bring in an application for an injunction to prevent them from using that information. So
100%.
Yeah. Okay. Natalie, how does the new job protected leave, like the sick leave, disability leave provisions in the ESA work in conjunction with EI sick leave?
EI sick leave. That's a good question. It's a good question because, as I said, because it's so new, there really isn't any interpretation or guidance that has come out with like anything yet. So it's a bit of a gray area. That's something that I'd have to look into.
Right. Well, I mean, I'll just say that they are different issues as well.
Yeah,
right?
True.
So if an employee is disabled, quite often it comes up where you don't have short-term disability. They can apply the EI for disability benefits. That's different from the disability leave provisions in the ESA, right? Sure. So, and you might have a situation where they get denied disability benefits for whatever reason by EI, but you're giving them the leave under the ESA, or you might decide that, in fact, they're not really disabled and they shouldn't be getting it under the ESA. And if you're in those kinds of situations, you definitely want to get legal advice on how to navigate the situation.
And also the long-term illness leave, it's more so for something that you're very likely going to recover from, and it's more of a short-term fix. Like if we're looking at STD or LTD, they're usually a bit longer than what this specific leave is aimed at covering.
Does anyone have a question from the audience before them that they want to answer?
Yeah.
Go ahead.
So I've got a question which is near and dear to the hearts of just about everybody attending, I think. Are HR staff fiduciaries? So if someone here is thinking about quitting and starting a competing business because they have access to sensitive data, and et cetera, et cetera. So they definitely have a duty of good faith. An HR person who's not at the sort of C-suite level is unlikely to be a fiduciary of that company. Okay, like if they are setting the, labor policy for the entire organization, maybe, right? So they're the most senior HR person. They would be considered an executive at that company. Then it's possible, depending on the circumstances, that they're a fiduciary. But there is no doubt that they have a duty of fidelity. There's no doubt they have a duty of confidence to keep all of that highly classified information that they have about the employees in the organization strictly confidential. And in particular, they are the the holder and the enforcer of a number of privacy legislation obligations that pertain to the access of the information that's individually identifiable about those employees, their personal health information in some cases, and they can be personally liable if they violate that, not just to the company, but to the employees. So whether they're a fiduciary or not really will depend on the circumstances, and it seems unlikely for most HR folks. But if you're dealing with a large organization and they're sort of a C-suite level, they might be. Another question, which is sort of dealing with what happens after somebody leaves. If I have a second, I'll answer it. Is that all right?
Yeah, well, we'll go over to Ryan. I have a good one for Ryan.
Let's do Ryan.
And then you can think about your answer. Okay. So Ryan, if criminal charges are filed against someone for health and safety violations, at what point does the right to remain silent take effect?
Oh, that's a great question, because we have to kind of contrast what the context of every single accident will be investigated by the Ministry of Labor. And the Ministry of Labor in the Act, it says the inspector has the right to make inquiries of individuals. And if an inspector requires you to give a statement and you don't do so, that's considered obstruction of justice. And you can be charged under the Health and Safety Act for obstructing an inspector. But, of course, in the context of a criminal case, you have no obligation to speak to the police. They can't compel you to give a statement. But if you do give one, and we've all, watched American TV and heard the Miranda warning, which in Canada is called a caution. And if you give a caution statement, anything you say can and will be used against you. Or if you say something to the police voluntarily, that's admissible in court against you. So how we deal with these situations, and we do it all the time, is to say to an inspector, is this statement voluntary or not? Or are you requiring this statement? You're compelling me to give this statement. The second that statement is compelled, it's inadmissible in both an OHS proceeding and in a criminal proceeding. It's not ideal. You'd rather not say anything, because we know the police could get those statements. But if they did, but it's the closest thing you can do is to use the magic words is voluntary. And if the statement's voluntary, don't give it without legal advice. Because most of the time, what I'm going to say to people is it's not in your interest to give a statement, or it may be that you respond to questions in writing or you provide certain information. But if the statement's required, you're going to have to give it. You'll have to give that statement, or you will face, the advice will be you'll face obstruction charges, which is unfair, but that is how it works.
Natalie, I have a question for you. Mm-hmm. What if we use a third-party recruiter to advertise our position and they use AI? Would the obligation to disclose if you're using AI apply?
Okay, yes. So the obligation to disclose that you're using AI, the Act is quite clear that you can't delegate that responsibility to a third party. So even if you are using a third party recruitment firm, it's still the employer's obligation to double check that that third party is putting all of the required elements into the job posting. So it's not something that you can hand off to them. So make sure that you're being cognizant that the third parties you're working with are compliant. And also, I thought more about the question that you asked earlier about the EI. I misunderstood the question. They kind of go in tandem, and that's exactly why the long-term illness leave was introduced. It was to align with how long you can get EI sickness benefits. So absolutely, if you're eligible, of course, to apply for the EI leave and to get the monetary benefit, it's going to align exactly with how long you could take the leave for. So I didn't understand the question until I thought about it more.
Question for Jeremy. Were you saying that we have to give an employee something, like as consideration, to sign an employee handbook? And what if we make changes to the handbook every year or every other year? Do we have to give them consideration for those changes?
Okay, so I'm going to re-ask that question. And the question is, what is the appropriate stuff to put in an employee handbook that we can make changes to whenever we feel like it? And what is the appropriate stuff that should be in a separate document that the employee signs in exchange for consideration, whether it's in their contract or it's a separate policy that they sign off on in exchange for something fresh? So if it is already part of your implied management rights, to use that sort of union term, unionization, collective bargaining term, it's something that is a normal policy measure that the employer, in their management responsibility of that business, needs to make the rules about how things work. You might change the way you're going to bid for vacation, or the practical matters of running the affairs of the business. That's what handbooks are for. If you're going to have a non-competition or non-solicitation agreement, that's not what your handbook is for. If you're going to have that policy in your handbook, that's fine. It's not going to be enforceable just because the employee saw that handbook, unless they saw that handbook when they signed their employment agreement and received the employment as their consideration, or you give them fresh consideration when they sign off on that handbook containing that policy. You don't want to bury something as important as non-solicitation, non-competition, or anything else that puts incredibly onerous or disadvantageous provisions, which either take away someone's rights or create new obligations that are not normal, right? That's something extra that you're asking for that's not just part of the normal day-to-day business of your operation in a handbook. You want it to be in a separate document. You want it to be referred to in that contract. You want to make it clear they're getting consideration when they do it. Otherwise, eventually, when you try to enforce, whether it's a non-solicitation or anything else, that weird provision that you buried on page 5 of your 20-page handbook, they're going to say, I never really read the handbook. You didn't give me any consideration for this onerous, unusual thing you're trying to impose on me. It will not be enforced by the court. So if you want whatever this is to be enforced by the court, if it's valuable to you and important to you, you're going to want to put it in the contract. You're going to want to put it in a separate policy. You're going to want to ensure there's fresh consideration for this thing that is beneficial to you and onerous or disadvantageous for the employee. And so if you're not sure whether this thing you're trying to impose is a new and onerous thing that you need to give consideration for, check with legal counsel. But something like a non-solicit, non-competition agreement, putting in the handbook, you may as well put it next to where the commissary is. It's not an enforceable deal.
Right. I mean, just to add to that, I think your employee handbooks should be for things like policies, like your harassment policy, workplace violence, civil respectful workplace procedures. How do you claim for expenses? If you're going to be late, what's the number you call or who you email? Putting in vacation requests, maybe your vacation policy, things like that. The kinds of things that you as an employer have an inherent right to regulate and determine for your employees' working lives. But things that are like, as Jeremy was saying, that are individual, like contractual restrictions on rights that employees might otherwise have, like non-compete, non-solicit, termination clause, that kind of stuff. That should be in your individual contract or employment offer with the employee. And when you're changing those kinds of provisions, then you should give consideration. So, okay. I have one for Sarah. What would be a reasonable time frame to recall an employee from remote work back to the office and have the courts define that? Example, like, would 30 days be enough, or do we have to give 3 to 6 months?
Again, classic lawyer answer. I think it depends. Now, I think 30 days would likely be too short. I think giving as much notice as you can within the constraints of operational needs is always your best practice here. And again, there should be certain considerations taken into account, such as how long has the employee been working either fully remotely or on a hybrid schedule? Is the remote policy across the entire workforce, or is it this specific set of employees? So I do think 3 to 6 months is a safe range. Again, if there's clear communication about the expectations and about the timelines, I would say that 30 days is probably a bit tight.
I have this question I'll actually throw out to either Sarah or Ryan, and Ryan's our resident health and safety expert. So it kind of crosses that area. But here's the question. With the Occupational Health and Safety Act applying to private residences where remote work is performed, what are the obligations of the employer or the Joint Health and Safety Committee to perform workplace inspections? We have a comprehensive policy in place that includes remote work agreement, hazard, and ergo assessments, and allows for the employer to attend at a mutually agreed upon time. But we have never exercised this option and are considering starting this.
Well, you've raised a very interesting issue. This is one that I've been asked many times when these full sort of provisions came out applying, extending the provision of the Act. And ultimately, the answer is if you have developed a contractual right and this is properly contractual, like it's in a contract as opposed to being in a handbook or policy, which alludes to our further question, then you can set up at a mutual agreeable time to do an inspection of someone's home situation. I have never heard of any client I've been asked whether we should do this. I haven't had anyone actually do it because the Act itself doesn't give you the right to march into someone's house and conduct an inspection of the Joint Health and Safety Committee. That is private property to which you do not control, and you don't gain access to it just because it's a workplace in the absence of a contractual right. If you have a contractual right, good for you. But I would be cautious about getting into a big fight with an employee on this particular issue. And the Act recognizes and courts recognize like what the courts always say, they measure due diligence by what an employer can actually do. And invading private property, at least at this point, is not something an employer can do absent access and a contractual agreement.
Maybe, Sarah, this is more in your jurisdiction, I guess, on remote work. So the question is, what if we have an employee who has handles documents, prints things out at home with highly sensitive, confidential information? What can we require or do to protect that information that they're keeping at home?
So first of all, a policy here is going to be your friend. You can provide the employee with a separate router to be used for and a secure connection to be used specifically for work. You can provide, of course, your own printer as well, and you can have clear guidance on this printer is only to be used for work related printing, not to be used for, your kid's science fair or, printing out plane tickets. But again, those would be costs that the employer would bear. You, of course, you should have strict guidelines on confidentiality, on the security of these documents that are being printed, on what should and should not be printed. Some workplaces choose to have certain documents only printed at the office. And some are okay with it being printed at home as long as they follow these certain criteria. You can also consider providing a small at-home shredder for the security of the documents. There's a lot of individualized contextual steps you can take to ensure the protection of the documents. I think, again, number one is a clear policy that you implement so the employee knows exactly what is expected of them, what they can and cannot print, and how they can destroy and control these documents safely.
Now, there's a second part to this question too, which actually I'll just quickly answer about whether or not secure internet connections can be required for security of information. And if so, who pays? So first of all, one thing just to know, like, beware of public Wi-Fi's, right? If there's no password on that Wi-Fi network, if you're at a Starbucks and you can just use the Wi-Fi in there, someone else in that Starbucks can easily, if they know what they're doing, get access to your computer and take all the information, right? Or hack into it. So I think it's a good idea if you have a lot of remote workers to have a policy, just like Sarah was saying, policies are your friend on these issues, setting out rules in terms of where and how employees can access internet connections. And I think it'd be a good policy that you cannot use public Wi-Fi that is not secured with a password for work, right? To protect your data. Now, in terms of home connections, you could also have a requirement that people's home connection be secured with a password, right? Apparently, some people have their home Wi-Fi without password protecting it. Huge security risk. So not a bad idea to have that in there. Now, in terms of who pays for the internet connection, That hasn't really come up to me. I think most employers are just assuming that the employee pays for their remote connection, and that's just the way it goes. But that is something I think it could be negotiable between an employer and an employee, especially if the employer requires a high-speed connection. An employee might be able to say, well, okay, then, please pay for it. But there's no legal requirement for you as the employer to pay for their internet connection. A couple questions, and again, like Ryan he's our resident WSIB expert, so I'll throw this over to him. Questions about WSIB coverage, because Sarah was talking about how it can still apply for people working remotely, but this is just a broader question. What types of industries are required to be covered by WSIB, and what about salespeople working remotely? Are they required to be covered by WSIB?
Well, I mean, here's the thing. 90% of employers are required to be covered by Workplace Safety and Insurance Act in Ontario, and their Schedule 1. Virtually the entire public sector has to be covered by the board, and they're generally speaking, but not exclusively, Schedule 2 employers, which means they're effectively self-insured. There are the exemptions tend to be for lower risk industries that are where the risk of injury is fairly low. Law firms is one of those, but accounting firms are required to have WSIB. Explain why that is. I don't know, but so sometimes there's no rhyme, no reason to it. Banks and stuff optional. So I mean, you have to. It's basically you just have to look at what your industry is. And where it fits within the North American classification system as to whether it's covered by workers' compensation or not. And then this issue can be very complicated depending if you have multiple business functions and things along those lines. But the bottom line is that you have to be most of the time you're going to have to be covered by WSIB. Salesmen, it depends on what kind of industry. If you're employed by an industry that's an employed salesman, it depends. If your employer is covered by workers' comp, I mean, this is how workers' comp works. If you work for a roofing company, you're paying the same rate on the person who answers your phone as the person on the roof. That's just how the system works. So you're a salesman. If you're covered, then you have to be covered. If they're independent, then that's a different story. But if they're actually your employees, that within the meaning of the definition of worker under the Act, which is very similar to the Common Law or Employment Standards Act definition of employee or worker, it's just a function of what the industry is as to whether you're covered or not.
I think we can squeeze one more. We're right at 12 minutes, but we'll squeeze in one more quick one. Natalie, does a 3-year record-keeping requirement of any public job posting apply if the employer has less than 25 employees?
No, it does not.
Okay. 12 noon. It is our lunch break. We will take 1 hour. We'll see you back at 1 o'clock.
Okay, thanks very much. I hope you guys enjoyed a respite. We've now got my partner, Jeff Murray, joining us to discuss addiction, accommodation, and termination, a perennial topic near and dear to our heart. I enjoy personally getting those phone calls from frantic clients wondering if it's okay to terminate that person who they forgot was still an employee 3 years after they finished working. So, Jeff, why don't you walk us through this minefield?
Hello, everyone. Okay, so Jeremy has told you what the topic of my presentation is. Thank you, Jeremy. And it is a chronic problem that employers must navigate now more than ever. It is manifest in many ways, and many ways that are sometimes difficult to perceive. Most commonly, we see it in terms of poor attendance. We see it in terms of poor performance. We see it in terms of safety concerns in the workplace. And it is an issue that managers and human resources professionals and legal counsel are often approaching with trepidation and somewhat feel disempowered to deal with, because they are at a disadvantage in light of the difficulty in actually identifying these problems as they arise, and for the lingering human rights issues that are part of these problems most of the time. And so today's presentation is primarily designed to deal with the human rights angle of this problem and to attempt to perhaps demystify the issue and give you a better framework with which to approach these issues. So I'm going to hit a number of topics. The first actually should say workplace impairment is bad. I left that out of the slide, but it's true that workplace impairment is bad. It has been considered bad in law for a very long time. And I'm just going to go into some of the common law background dealing with addiction in the workplace. The second is the workhorse of the presentation, and that is the duty of the employer to accommodate disability in the workplace, particularly that of addiction, either to drugs or to alcohol. We'll then go on to how you actually do that, and that necessitates a conversation about how employees must prove disability in general and how they must prove addiction specifically, and not just proof that they have an addiction or alcohol dependency that raises the duty to accommodate, but their requirement to prove that that issue actually is connected and linked to the behavior that they are displaying that has required the employer to intervene at that particular time. I will then go on to discuss what I think is the most difficult challenge for management, which is the duty to inquire under human rights law. And that is essentially to not be willfully blind or to turn a blind eye or whatever euphemism you want to use, but to actually see the problem that is in front of you and have the hard conversations that they require and not fall back on the fact that an employee may not be raising an issue that should be, if not obvious, perhaps a suspicion that you have. And finally, we'll get to what's very important, and is something that we converse with our clients a lot, which is, when is it undue hardship for you to no longer have to accommodate an employee that has established disability, either to alcohol or to drugs? So a lot on the agenda. Let us begin. So as you see, workplace impairment is bad. And we have known that for a while, but we have known that in a bedrock sense since the Ontario Court of Appeals decision in Entrop versus Imperial Oil in the year 2000. That case basically concerned when the employer can randomly test employees for drugs and alcohol to detect whether the person has drugs or alcohol in their system. It's not a case particularly dealing with how you manage the person once those issues have been uncovered, but it's useful to simply establish that there the Court of Appeal was very clear that freedom of impairment is a bona fide occupational requirement. You're not allowed to be impaired at work, and impaired employees are incapable of performing their essential duties. And that's why it is undue hardship for an employee to be impaired at work. The case brings out a fundamental theme, which is that this issue engages significantly with health and safety law, and it places particular emphasis on the employer's requirement to take every precaution reasonable in the circumstances to ensure health and safety in the workplace. And therefore, the issue of impairment at work is particularly important in connection with safety-sensitive positions. So, workplace impairment is bad. The second relevant common law case that deals with impairment at work, and I've selected this case because it does not have the classic human rights overlay to it. It was simply a case where an employee of long service, 23 years and 45 years of age, crashed the company truck after a 4-beer lunch. Obviously not something you're supposed to do. The employee handbook specifically prohibited consumption of alcohol off premises, while on duty and warns of possible termination. One would think the employer doesn't have to put that in the handbook, but significantly and to the benefit of this employer, they did. And the employee was very seriously injured with life-threatening injuries, and the employer allowed the employee to recover sufficiently so that they could actually come in for their termination meeting, which I think was quite generous of the employer. The case is pronounced Dzelski versus Lighting Dimensions. In that case, the court found just cause to terminate the employee. The court, however, cautioned that intoxication at work or during the course of duties is not presumptively just cause to terminate. And the court made very clear that the nature of the job and the circumstances of the impairment are very necessary to consider. And in this case, let me just go back to the nature of the job. The court acknowledged that in many workplaces, particularly white-collar workplaces, alcohol has a function. Salespeople often go to social events. Alcohol is a social lubricant, and so it is not completely prohibited, but the employer needs to recognize that if they do from time to time permit drinking either at work or in the course of duties, that is not sufficient in and of itself, the consumption, to provide just cause. In this case, the employee engaged in drunk driving. The employee engaged in drunk driving with the company's vehicle, and the employee handbook said, you're not supposed to be impaired at work. As such, the employer had just cause to terminate a 45-year-old employee with 23 years of service. Lessons learned here are pretty straightforward. Context matters, and the employer's policies matter. And finally, third-party safety is critical. In this case, the employee went out onto the public highway and threatened the lives of innocent third parties, which had a very damaging potential consequence for the employer's reputation. So that's kind of the baseline with respect to impairment at work. Let's get to the major complicating factor, which is the duty to accommodate. Now, the leading case with respect to the duty to accommodate impairment at work is Stewart versus Elk Valley Coal, a 2017 decision of the Supreme Court of Canada. In that case, the employee worked as a loader operator in an open pit mine. Now, you may not know what that is, but it's essentially somebody that operates a very big piece of equipment that excavates coal and puts it in very large dump trucks. So very safety sensitive. The employee got into a very minor accident at the work site. No one was hurt. The vehicle was fine, but that triggered the employer's policy that allowed it to engage in post-incident testing. So it did. And what came back was a positive result for cocaine. The employee was brought in and terminated, and at that point said, look, I'm addicted to cocaine, so you can't fire me. And the employer nonetheless fired the employee. Significantly in this case, Elk Valley Coal had a policy that it called the No Free Accident policy, which basically said, if you're addicted to drugs or alcohol, you have to tell us, and you have to tell us now before you get into an accident so we can start the accommodation process. And if you don't tell us and we find out that you are impaired at work, then we will terminate you. So that laid the factual foundation before the Human Rights Tribunal, the reviewing courts, and ultimately the Supreme Court of Canada. Let's get technical for a second. When you deal with any human rights issue, you've got to consider two things. One, is what you've done prima facie discrimination? And if it is, have you executed your duty to accommodate the employee? So in this case, the court laid out what the test for prima facie discrimination is. And those of you that encounter human rights law from time to time will know that this is remarkably a very technical, rules-based assessment, even though one would think anti-discrimination laws should sort of operate at the gut check level, but it doesn't. For there to be prima facie discrimination, the employee needs a protected characteristic. In this case, the employee was an addict and so had a disability. That was a protected characteristic. The employee has to have experienced adverse treatment. In this case, the employee was terminated. So here you have a disabled person that's terminated, but that's not the only test. The third criteria is the one that really matters, which is that the protected criteria has to be a factor in the adverse treatment. So the adverse treatment has to somehow be tainted or related to the protected characteristic. And in this case, the court and the tribunal below it held it wasn't. It wasn't prima facie discrimination simply because the employee was not terminated because they had a disability. And in fact, the termination had nothing to do with the disability, but rather the non-compliance with the employer's policy. That policy that says, if you have a problem, you got to put your hand up and we have to talk about it. And so the termination related to non-compliance with the policy and not because the employee got in an accident and the employee was addicted. So, having gone a bit technical here, key conclusions are simply this. The employee has a duty to prove that they have a disability. The disability must be the cause of the adverse treatment. And we should conclude that not all substance situations are related to an addiction. And so whenever somebody is impaired at work, and these cases generally don't come up in the case of the cocaine or heroin or hard drug cases, but they come up in terms of the use of softer drugs, particularly cannabis. And there's a requirement for the employee to establish that, in fact, their behavior was connected to the reason why they were terminated, or rather their addiction was connected to the reason why they were terminated. Obviously, employers should consider doing what Elk Valley Coal did, which is upfront, before anything happens, have a policy that says you need to put up your hand, you need to ask for help, and then we will help you if you do that, because that then allows you to fall back on this as a precedent when issues arise later and it comes to existence that the employee didn't put up their hand. Okay, so the employee has to prove disability. We know this from a 1994 case of the Supreme Court of Canada, which dealt with the various responsibilities of the workplace parties, one of which is the employee, the second is the employer, and the third is a trade union if one existed. And the court there, and ever since, has concluded that accommodation is a reciprocal multi-party process, that the employee has to actively participate in it, and that the employer is not required to accommodate an employee where the employee does not establish a need for accommodation and withholds reasonable information. So keep that in mind and park it, because we are going to get to the whole issue of the duty to inquire, because in some cases there is an exception to this principle, but generally it's the operating principle. Now the employee, or rather the employer, can ask, contrary to many beliefs of employees, their unions, and many managers, the employer can ask some rather intrusive questions when faced with this situation or any situation where an employee is claiming disability. The employer can ask for medical information that addresses each of these things, whether the employee suffers from an addiction. So you got to prove you have an addiction and that this isn't just a case of you using. How the addiction manifests functionally. And I want to pause on that not only must the employee prove an addiction, but they have to prove and explain how that addiction caused them to not come to work, to engage in misconduct, to have work done safely. So there's an added element there of causation and explanation. Obviously, questions with respect to restrictions and limitations, as well as prognosis and treatment engagement, which is a critical issue too. An employee is not entitled to be accommodated without showing the employer that it's actually doing something to accommodate himself or herself, that the employee is doing what he or she can do in order to solve the problem that now the employer and they must deal with. Now, I'm sure you've all, or most of you, have dealt with a situation where someone's worked unsafely, someone's not coming to work, and you've gotten to the end of your rope and you've either terminated the person or you're about to. And it's at that point they put up their hand and they self-declare that they have an addiction with respect to drugs or alcohol dependency. And so a useful case to discuss this is that of Canadian Pacific Railway, which dealt with a locomotive engineer that was operating a train while impaired. Again, very bad, not recommended. The employee had 33 years of service. We can only assume the person was well into their 50s and had very little discipline. His train collides with another vehicle, and an investigation ensues. The RCMP show up. Whiskey is found in the engine, and the employee blows over 0.08. It's at that point that the employee admits that he consumed alcohol on duty, and after he's terminated, then says, "Oh, and by the way, I'm an alcoholic." Now, I think Canadian Pacific's probably learned from this case. But several weeks after the termination, this employee is represented by a union. The employee may not be thinking straight, but the employee's union is. And the union discloses to the employer very extensive medical information that deals with the employee's treatment records, diagnostic records, the fact the employee has entered a 2-week residential treatment program, and the case proceeds. Canadian Pacific doesn't back off. They take the position that the employee was impaired and and that's the end of the discussion. The arbitrator says, "Well, I'm accepting the late proof of disability. I'm accepting that the disability is related to the termination. And you, Canadian Pacific, have not done anything to engage in this human rights analysis. And therefore, the employee is going to be reinstated and returned to work subject to conditions, testing being a paramount one of them." So I said a moment ago that the employee needs to establish the employee needs to establish not only disability, but the employee also needs to establish the disability is related to their behavior. Many of these cases are what I call the nurse stealing drugs line of cases. And this is one of the more early ones where a nurse stole a patient's narcotic pain medication, was found out, and claimed to have been an addict for many years and an alcoholic for many years and was undergoing stress. The nurse claimed that her drinking was out of control, and so she stole the drugs because she needed a pick-me-up because she had a hangover. The nurse entered treatment soon after termination. Now, who thinks the employee got their job back and was found to have been discriminated against? No hands up. I should just sit down. Very interestingly, in this case, the tribunal said, no, there's no discrimination here. The fact is that the employee's evidence was that she was experiencing symptoms of alcoholism, but she stole and took drugs. And therefore, one does not relate to the other. The nurse's judgment was not impaired by drugs or alcohol, and so no prima facie discrimination. The moral of this case is that employees, yes, they have a duty to provide evidence of addiction. They must demonstrate how the addiction is manifest, and this nurse was not able to demonstrate how her alcoholism was manifest. show how the addiction is connected to the workplace, and disclose addiction promptly. But the issue here simply is that the nurse didn't explain how the addiction was manifest. And so my advice to employers is this is why you have the conversation. This is why it's not just the employee putting up their hand, proving addiction, but the hard questions need to be asked. You and engage in a very long conversation about how long has this been the case? How did it relate to the fact that you're not coming to work? How does it relate to the fact you worked unsafely, etc.? So the employer should ask for a prompt explanation, ask detailed questions, and require medical substantiation of whatever it is the employee is telling you. Sears versus Honda Canada, this is a sort of a foundational case, and it simply means that the employer can't put its head in the sand. And this is not an addiction case, but it essentially involved an employee in an automotive assembly plant that worked in the quality department that was colorblind. And he couldn't see red, he couldn't see green, and he couldn't see yellow very well. And the new quality software was embedded with red, green, and yellow. And he was seen by the employer with everything, the documents up to his face, and he was making mistakes, and he was asking his friend to tell him how things looked. And the employer did nothing. He got frustrated and quit. And the employer, the tribunal found that the employer had a duty to accommodate there because the employee had a disability, colorblind, or had vision problems and color blindness that was related to the employee quitting against their will, and it was a factor in the employee quitting against their will. Honda said, well, the guy never said anything to us, to which the tribunal said, no, he didn't say anything to you, but it should have been obvious. You should have asked, and you can't rely upon that. So not an addiction at work case, but it's sort of one of the foundational cases that helps explain the principles. The duty to inquire, I would say the leading case in Ontario is another nurse stealing drugs case. The nurse was found in possession of narcotics, admits to stealing them, admits to using them. She doesn't claim disability at the time during the employer's investigation, doesn't ask for accommodation, and is fired. You would think the employer is free and clear. Well, the employer's union has encountered this problem before and disclosed after termination the fact that the employee was addicted and that she had been pursuing rehabilitation post-termination. And the arbitrator essentially said, well, clearly this is related to the addiction. The termination is related to the addiction. You have a duty to accommodate. Yes, Renault says that the employee has to put their hand up, but in this case, that wasn't necessary because the people in the workplace, and the evidence was quite clear, could tell that something was wrong. They saw the nurse walking around barefoot. They saw the nurse scratching herself. They saw the nurse going missing on the ward. And the arbitrator knows that nurses are a little bit more, and nurse managers are more educated with respect to recognizing the signs of addiction and should have, and therefore the employer should have accommodated this employee, but didn't, and therefore concluded the duty to accommodate was not met. So at this point, I've sort of laid out the principles without really talking about the defenses. Similar advice that's kind of been embedded what I've been saying thus far. Ask about the disability during the investigation. Raise the issue if you suspect drugs or alcohol is a connection. Require proof, and don't rush to decision. Pause before making your decision. But you do have a defense, and that defense is establishing that it's simply undue hardship for you to continue to employ this person that has been misconducting themselves because of this disability that they have. In that case, that principle was also discussed in the Humber River Hospital case. I'm ahead of my time. In that case, the arbitrator noted that the nurse in her testimony wasn't straight with him and hadn't been straight with the employer. What she said initially was her history of addiction did not dovetail with her testimony. What she said was her history of rehabilitation did not dovetail with her testimony. It came out that she had not been cooperative in testing. And so the arbitrator concluded that this is an employee in a safety-sensitive job. Nurse is a very responsible position that was addicted, and there was just too much of a risk of a recurrence. Even though the employer had not played this correctly, the arbitrator was not going to reinstate the nurse to employment. And so this is why you asked for the evidence. This is why you asked the probing questions, because you have to decide whether you're prepared to take a risk and pursue the rehabilitative path as opposed to the disciplinary and termination path. Key factors were the safety-sensitive nature of this job and the fact that public trust is particularly important in the nursing profession and the hospital industry. Okay, so the last case I want to talk about, also dealing with undue hardship, is an example of the employee that just can't do himself any favors. The employee was a line technician who works on high voltage lines with 15 years of service, gets into a fender bender in the company truck, really just a scratch. But it turns out that he's under the influence of alcohol. He had previous discipline and a demotion for destroying evidence of previous poor work product on his part. And he wasn't straight with the employer during his investigation. Now, the medical evidence showed that this employee had moderate alcohol use disorder. And the arbitrator adopts Elk Valley Cole, and concludes that the first two provisions of that test had been met, disability, adverse treatment, but that the medical evidence simply did not establish that that's why the employee was drinking that day. That the degree of the addiction, the degree of the alcohol use disorder was not so severe that the employee lost control of his drinking, and that's why the employee was in the cab. So in that case, no prima facie discrimination, but the arbitrator goes one step further and says, even if there was, it's undue hardship to have this employee back in the workplace. He's got a previous discipline record. So, lesson. As soon as you encounter these issues, take a disciplinary approach. Don't necessarily terminate the employee. Written warning, maybe a suspension. It's a safety-sensitive position. The employee showed little insight into his problems. Again, asked the probing questions during the investigation. The employee had taken tepid rehab efforts since termination. And again, the risk of recurrence was just too acute for the employer and arbitrator to reinstate this person to employment. So, a lot of moving parts there. Parting comments is develop a fit for duty test if you haven't already. Require mandatory disclosure. You want to fall within that particular exemption that was carved out in the Elk Valley Cole case. Ask the hard questions and don't be shy. Don't stick your head in the sand. If you suspect addiction to drugs or alcoholism is an issue, raise it directly, raise it often. Demand medical concerning proof of addiction, but also an explanation about how that addiction is affecting attendance or performance. Demand the employee be candid and require the employee to take meaningful steps to solve their own problem. Because if they're not doing it at all, it's undue hardship to expect you to do it all. So those are my comments on a very difficult topic, and I thank you for your time and for your attention.
All right. Thanks, Jeff. Hopefully that provided a bit of a roadmap through some very treacherous landscape. We now have, it seems like we waited until after you guys had some calories in you so that you can burn as you crunch through these topics. Frankly, Jeff and Allison have the hardest topics that are constantly creating risk and liability for employers. So I look forward to hearing Allison's take on how to draft termination clauses and what the courts have been doing, because it's always a fantastic update. And she's probably our most seasoned lawyer on this topic. So yeah, thank you.
Thank you very much, Jeremy. So I've been giving talks at these conferences for 30 years. And I think I can genuinely say that I cannot remember a time in which specific contract language has been so granularly reviewed as is happening in the courts today. This is part of a really, I guess you could say, a continuing process over the last 10-year period, perhaps we can say, in terms of termination language. But really, we are getting very much into the weeds now when we deal with contract language. And I'm going to deal specifically today with several issues. One is the line of cases that has devolved over the last year and a half or so, dealing with at any time termination language. I'm going to deal also with some kind of interesting cases dealing with repudiation and layoff, because they just interested me, frankly. How to draft termination clauses if you are one of those brave souls who wants to do this for yourself. And I say that advisedly. When and how to update your language to make it enforceable, or to add enforceable termination language to an existing employment agreement, and also some strategies for avoiding costly risk. The lawyers acting for employees these days have really made a cottage industry out of attacking language, as I said, at a very granular level. And the at any time line of cases of this is of this nature, starting with Dufault, but you can see on the screen that I've listed a series of other cases on the same subject matter. The ones with the asterisks were heard jointly by the Court of Appeal back in March. As of this morning, because I checked, the decision had not come down yet. But in any event, the Dufault case is a very unsatisfactory case, because in that case, the Court of Appeal went around the issue to the consternation of everyone at the bar who would like to understand whether this kind of what we might refer to as boilerplate language is really problematic or not. Now, phrases like at any time, for any reason, in their sole discretion, that's the kind of language that is near and dear to the heart of lawyers. It needs to be kept in mind that lawyers write a lot of different kinds of contracts. And in commercial agreements, this kind of language is intended to show the extent of the prohibition or the permission or whatever it is that the subject matter is about, in order to show that a situation will, or a result will apply in any circumstances whatsoever. So it has a function. I want to say that advisedly, because sometimes language like this is very much boilerplate. That is, it's just in the template from time immemorial when somebody drafted an original contract. But in an employment contract, regrettably, it's a different kind of contract. And we cannot really use this kind of boilerplate language without looking at the context in which we're doing it. And the context in which we're doing it is a vulnerable population on the other side, that is, employees who are not legally trained, who are often not legally represented. And so we can't really have that scope of breadth to language without it being for a good reason and rational. And as I said, lawyers like words as well. We tend to write more rather than less. We write more broadly, more inclusively. We're wordsmiths, and that's part of what we do in terms of serving our clients to try and ensure that all possible circumstances are captured by a particular clause. The problem is that uniformity when you're dealing with employees, and more particularly with the impact of the Employment Standards Act in terms of contract language and requirements relative to ESA entitlements is a context that is special. And we simply can't get away from the fact that it is special. And we can't, partly because the plaintiff bar has creatively come along to remind us of that fact very frequently. So I'm going to talk about that line of cases first, Dufault and following. I'm going to talk about 3 other recent cases on enforceability of termination clauses, because there's language that's near and dear to my heart and I think is instructive to help you in terms of interpreting language you see. And then a couple of other interesting termination clause cases, which I think are instructive. So I want to start with Dufault. And Dufault is a case of an early termination clause in a fixed term contract, fixed term contracts being anathema in my world, because if you don't get your early termination clause exactly right and it's void, then the damages are fixed for the balance of the term. And that can be far more than common law notice. So word to the wise, try and avoid fixed term contracts in any event. But in this case, there was a fixed term contract, and this is a township of Ignace, I guess that's how you pronounce it. And so this employee was terminated early, got 2 weeks of notice, and the termination clause said that the township may terminate this agreement and terminate the employee's employment at any time and without notice or pay in lieu of notice for cause. And then the not for cause clause went on to say that the township may, at its sole discretion, terminate in accordance with a listed set of terms. So in this case, the employees' counsel said there's a problem with the phrase at any time, and there's a problem with the phrase for cause. And of course, the for cause problem relates to Waxdale. And the fact that employment standards does not provide for cause as a basis for termination without notice. It provides for willful misconduct, disobedience, or willful neglect of duty as a basis for termination without notice. So the Waxdale problem was very clear, I would suggest, in this case. And so, of course, Mr. Dufault, I think it was Mr., can't remember, was awarded common law notice on 3 grounds. Firstly, the for cause clause was void because it exceeded the scope of what might be expected relative to the Employment Standards Act willfulness standard, which has to do with being bad on purpose, right? So simply being in breach of a contract is not sufficient. The without cause clause, interestingly, also limited the basis of payment under the ESA to base salary, also a violation of the ESA. But the third issue is the one that made everybody sit up and take notice. And that was the use of words like sole discretion and to terminate at any time. And let's just go back and look at that language. So you can see in 402, it says the township may at its sole discretion, blah, 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 at any time terminate. And the employees' counsel argued, and the court accepted, that this was a violation of the Employment Standards Act because in some circumstances, you just can't terminate an employee without violating the act. For example, if someone's coming back from maternity leave, they can't be terminated, arguably, without violating the act. If there's an act of reprisal, then again, they can't be terminated without violating the act. So the employer goes off to the Court of Appeal, and the Court of Appeal basically skirts the issue. The Court of Appeal says we don't need to decide about the discretion and at any time language because, in fact, this is a very straightforward case about cause being too broad, and we've got lots of other case law on that subject, and we're going to decide that case in conformity with that case law. And they left the issue regarding whether at any time was problematic to another occasion. And so all of us in the employment bar ripped our hair out at this point because every contract practically in the world, employment contract says things like, we can terminate you at any time for any reason, blah, blah, blah. And suddenly all of these innocuous clauses that nobody writes on purpose and nobody thinks about or worries about or has any relevance to anything is suddenly going to be a big issue. So then we have a whole line of cases that follow this initial case in which, by and large, the language is found to be problematic, but not exclusively. And I'll come to that in a moment. So the Baker case was a case in which the employee, again, was terminated without cause. The termination clause said we may terminate your employment at any time without just cause, in providing you with only the minimum notice or pay in lieu, and if applicable, severance pay required by the Employment Standards Act. Then it goes on to talk about benefits. And then it says basically, if there's anything that's prescribed by minimum standards, we'll pay it. Now that looks like a very thorough, accurate termination clause. And then it goes on to say about cause, we may terminate you for just cause, et cetera, except any minimum compensation or entitlements prescribed by the Act. And then it provides a list of just causes. And I've highlighted the ones that are clearly not willful, right? And this is the reason why you just don't want a clause that lists causes. Because some of them, like falsifying documents, theft, etc., those things are willful acts and are likely to support willful misconduct under the ESA, but poor performance won't, and any conduct which would constitute just cause at common law won't, because by definition, that is a broader definition. So the court held that there were several reasons that this clause was void. One, of course, is the just cause clause that I just talked about. And even though the employer said, we will comply with the Employment Standards Act, it just didn't matter because, in fact, that listing is more specific and supersedes that contracting or that saving clause. But it also said at any time implies a completely unlimited right to terminate despite any surrounding circumstances, and that violates the ESA because the ESA provides times where you can't do that. By contrast, the Lee case was a case in which Lee was terminated after 9 months of service under this termination clause. Again, the company may terminate your employment at any time for cause without notice, and then it lists notice, severance, benefits, etc., unless expressly required by the ESA, in which case only the minimum statutory entitlements will be provided. So far, so good. Looks like it's intended to capture all of those things. And then it goes on to define cause as meaning willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the company, and that constitutes cause under the ESA. Frankly, I would have jettisoned the last part of that sentence because it's unnecessary. But in any event, the point of this was to show that the employer was dovetailing its definitions directly into employment standards. And then after the clause goes on to say, in the absence of cause, the company may terminate your employment at any time and for any reason by providing you with only the minimum statutory amount of written notice or pay or combination of both, statutory severance pay, benefits, etc. So again, very comprehensive language. All the points are hit. The Superior Court, bless them in this case, found that clause to be enforceable, notwithstanding the presence of the at any time language. It said that the clause repeatedly reinforced compliance with the ESA. And you'll see later that that may or may not be a major point because intention is subjective, and I'll get to all of that in a moment. It distinguished Dufault by saying, well, in this case, at any time is that mere language without broader language about discretion and so on was not enough to automatically invalidate the clause. So that little phrase, innocuous little phrase, was not enough. Lee's contract did not contain that fatal definition of cause being this laundry list of things. It was specific about ESA, no problems there. And so Lee was limited to the ESA minimums. And I hasten to add that all of these cases are ESA minimum clauses. That's why the employer is bothering at all, is to keep people to the minimum standard. And one really needs to question whether that's always a great idea in light of all of the attacks on these clauses. Now, Lee and Baker were heard together before the Court of Appeal. One says at any time voids the contract. The other says it doesn't. Hopefully this time the Court of Appeal will not wiggle out of that issue, but will directly tell us whether that kind of language is suspect or not. That being said, I these days am going with my little red pencil, figuratively, obviously, to take out that language because it literally doesn't mean anything. No case in my many, many years of experience has ever turned on whether that phrase was there. And if it doesn't, in the longevity that I have, trust me, it's never going to happen. It's never going to be important to you. It does not need to be there anyway. So it'll be an interesting exercise, but I know that lots of lawyers are simply axing all of this language that doesn't have a lot of function. That being said, there are many, many contracts out there that still remain to be examined. So then we've got some other cases, all of which don't follow the Lee line, if I can put it that way, but go the other direction. So the Jones case relates to a clause that says, again, the organization may terminate your employment without cause at any time upon providing you with the following. And it talks about notice, requirements for severance pay, benefits during the ESA, plus 1 additional week. So this is an enterprising employer that's trying to be a little bit more generous, hopefully intending that that will take the curse off it, if I can put it that way. And then it goes on to say, this clause goes on to say that you can be terminated at any time without notice or pay or severance pay. Now, pay attention to that language because that's important. For willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the organization. That is the kind of standard language that we use, that it encapsulates what the ESA threshold is. So far, so good, one might argue. And then it goes on to say, if your employment is terminated for conduct that amounts to just cause at common law, but not willful misconduct, et cetera, you will receive those amounts set out in A. And you'll recall that A is the ESA only, but not B, which is the additional week. So that looks like it ought to work, but it doesn't. The court does find that the words at any time by themselves don't violate the ESA. So far, so good. Doesn't discuss the Baker case at all. But the court then violates the clause, or finds the clause invalid due to an ambiguity in the with cause language. I'll flip back to that, about whether you get benefits or not. And I'll take you back to this clause. And this, you'll see in the second line that it says the organization may terminate your employment at any time without notice or severance pay. And it doesn't say anything about benefits. So the court says, well, that's ambiguous. So you got an ambiguity, so you're out of luck. So this is a case, in other words, in which the court, again, is not following that line of cases that directly say at any time is the problem, but it is wordsmithing to a considerable degree by reading in an ambiguity into this situation by virtue of the fact that the exclusion of severance pay in a cause situation or benefits continuance in a cause situation makes it uncertain what the result will be. And so it comes to the conclusion that the clause, because it's ambiguous, is void, notwithstanding the stringent efforts that have been made to try to bring it within the parameters of the law. The Chan case is a case of an employee terminated one day before the probation period ended. And the employer had a termination clause that said the first 3 months of your employment are probationary, during which time the company may terminate your employment at any time for any reason at its discretion without notice, etc. First word to the wise, if you're going to call employment probationary, just call it probationary and only have one termination clause. It's not necessary in a probation clause to talk about the outcome. And it's better to consolidate all termination clauses in one place, because if you don't do that, you may find that you've got termination language scattered throughout an agreement, which can have the effect of voiding all of the other language. But you can see that we have that suspect language at any time, for any reason, at its discretion. And this is during a probation clause. And then it goes on to say that after the first 3 months, employment can be terminated at any time without cause upon providing the ESA amounts. And then it goes on to say the provision of this notice, etc., shall constitute full and final satisfaction of any claim which you might have arising from the termination of your employment, save any claim that cannot be released. So this is release language. Again, not really a good idea to put release language, because that's not really what you need to say. What you really need to say is the common law is excluded, period. And then the cause clause goes on to say, terminate for cause without any obligation for notice, severance pay, or other obligation. So the court went to town on all of this language. And it said, well, at any time, for any reason at its discretion, is unenforceable based on Dufault. That even if you're probationary, you have protections, certain protections under the ESA, which would make that termination illegal. That is, therefore, language which contracts out of the ESA. At any time without cause, in the without cause clause, similarly, is invalid based on Dufault. And remember that even though this person was probationary and that clause didn't even apply to them, all of the clauses get looked at. And if any of them is void, they're all void. Then, of course, the cause language is overbroad again. And then using Waxdale, the whole house of cards gets brought down and Chan is awarded 3 months' pay. So again, we've got courts now saying we have a problem with this boilerplate language that looks innocuous, but really is saying we can axe you on these terms regardless of any other rights you might have. Now, interestingly, the federal jurisdiction even has a case like this now. And the reason this is interesting is that the federal jurisdiction under the Canada Labour Code doesn't use willful misconduct language. They have a just cause standard. Other provinces also have a just cause standard, but the courts are clearly paying attention, even in that context, to the existence of any at any time language and whether that is a violation of statutory rights. And of course, the Canada Labour Code for federally regulated employers has the same kind of protections for termination under certain circumstances for federally regulated employees that the Employment Standards Act has. So this is a CIBC case, and CIBC has a lengthy agreement saying that, again, termination can happen at any time for cause, and then it lists a whole lot of causes. And at the end, it says if your employment is terminated for cause, you have no entitlement to anything. And then without cause, again, CIBC may terminate your employment at any time without cause, and then there's a formula provided, and then there's a release. And if the employee doesn't sign the release, the second paragraph goes on to say, well, then you just get the minimum standard. So again, given that the Employment Standards Act cause definition isn't an issue, that's not a problem. And this kind of language was previously held in a case called Horwitz to be enforceable. But the court says, well, I'm interested in this new case law on the language at any time. The at any time issue can arise just as easily in connection with the Canada Labour Code as it can with the ESA because of the protections in the code. So I'm going to apply that. That line of cases at any time is void. Waxdale invalidates everything, and the employees get notice. And this is in the federal jurisdiction. So we can see that the courts are more courageous now, if you like, about saying, well, we cannot treat any language as just being casually thrown in or being throwaway language. All words have a meaning. If the meaning happens to be one that voids the act, whatever jurisdiction you're in, then you're in trouble. So once the Court of Appeal comes down with its decision on Baker and on Lee, we will hopefully know which of these lines of cases the and in what context, because some language, as you can see, is at any time, for any reason, at their sole discretion. It's much broader, and other language is just at any time. Hopefully, the Court of Appeal will give a broad elucidation of the governing principles here, and we will know the outcome. But as I said earlier, use of things like at any time, for any reason, unless there's a specific reason for using it, is really just planting a bomb, if you like, within your termination language without really a function. And I think it will be of interesting academic importance and also of importance relative to existing contracts out there. But for the purpose of drafting contracts today, I just would not use that language because I don't see much point in doing so. So I want to move on to a couple of other cases. Wigdor is an interesting case because it's what I might term a split the baby decision. This was a case in which the employee challenged the termination clause and also challenged the fact that his RSUs were forfeited when he was terminated. Very common scenario for those of you who've got options and that kind of thing. The clause itself said the employment is indefinite. Section 12 will apply throughout, even though you're not entitled to reasonable notice or entitlements except as set out below. In no event will your entitlements upon termination be less than those minimum entitlements set out in employment standards legislation. Now, you would think that when you make a statement like that, you're saying to the world and to the courts, we're always going to comply with the ESA. And that's our intention is to apply with the ESA. Unfortunately, they then went on through careless drafting to say during the first 3 months of your employment, including any prior service with Chatham Labs, which Facebook had bought, or its predecessors, the company can terminate your employment at any time by providing you with 2 weeks of advance notice. Now, 2 weeks of advance notice in a probation period normally would be fine. But this was a case where they had bought this company. And under the ESA, when you've got prior service for the employer, the limitation is not of that nature. Severance pay can be applicable all the way back to kingdom come. Hence, there's a contracting out problem. And the saving provision, as has been the case in many other cases, was found to be ineffective. But as though to soften the blow for the employer, the court held, well, but the employee is going to get 10 months of notice, but we're not going to give the RSUs. And the court relied on a case with an obiter comment called North and Megaswitch Networks, which essentially said RSUs, options, whatever, share, purchase, whatever you want to say, this kind of additional form of compensation is not wages, and it's not regular wages under the ESA. These kinds of plans almost always say you don't get these amounts after the date of termination, and the date of termination may or may not be properly defined, but let's assume it's the day you walk out the door. And in fact, they may go on to say, and that it excludes any notice period that may be applicable to you, including a statutory notice period. So the argument is, well, you're excluding the statutory notice period. You're not supposed to do that because the ESA requires everything continue during the statutory notice period. So that's a contracting out. And the court says, well, no, because these are not wages or regular wages. This is a separate agreement that has nothing to do with the employment agreement or the rights under the employment agreement, and therefore the forfeiture is proper. And this is quite new case law because we all know, hopefully, that whether you give working notice under the ESA or pay in lieu of notice under the ESA, the employee is supposed to get everything they would have had working notice been given during that ESA period. There's supposed to be equality between the outcomes, whether actual working notice or pay are given. And so this essentially says, well, it doesn't matter that a person who got actual working notice might get vesting during that period, but somebody who gets money instead won't. And that, of course, is problematic. So Both parties have appealed this. This case went on appeal before the Court of Appeal at the end of April. The employer is challenging the 10 months reasonable notice, i.e. the common law outcome, and the employee is challenging the loss of the RSUs. And it'll be very interesting to see how the case comes down. But it did seem to me a little bit as though this was essentially splitting the difference by the court on the basis of doing what it felt it had to do with respect to the ESA on the one side, and then interpreting the ESA in this highly unusual way on the other side to give the employer some relief. De Castro is a case from 2025 as well, which it is a case of too many words. And this is why I say that it's so unusual to see a court being so very granular about language. The language says, if you are terminated for cause, or you have been guilty of willful misconduct, disobedience, breach of employment agreement, or willful neglect of duty that is not trivial, etc., then nothing has to be paid to you. Now, you've got to wonder why anybody bothered inserting the additional words. Why insert for cause? Why insert breach of employment agreement? Clearly, it's the drafter knows what the ESA formula is. Why do this? Is it love of language? Is it trying to broaden the range? I don't know. And I can't really account for it because it's very sloppy language. And then it goes on to say, it defines cause, and it says, cause shall include your involvement in any act or omission which would in law permit arista to, without notice or payment in lieu, terminate your employment. But the problem is that might have been fine if the word include hadn't been used, right? Include means it's this, but that's only one thing. It could be a bunch of other things as well. Why use the word include if you're going to define it? And why do it that way when you've already talked about the ESA in the paragraph above? This is really wordsmithing that's essentially throwing words into the pot. And I can't caution you too much about not doing this, because what might have been an acceptable agreement with a nice red pencil, unfortunately, didn't end up that way. Now, the employer argued, and this is where I get into this question of subjectivity, that the definition of cause showed that it did not intend to breach the ESA. It intended to comply. And the court said, I don't care with what you intended. I'm not interested in your subjective intention. What I care about is what words you used, right? The words are what matter. The words are all that matter. Because if intention mattered, all of this saving language would be saving clauses every which way, wouldn't it? And that's not what's happening. You have to say what you mean. You have to say what is in compliance with the law. And the fact that you mean to comply with the law, but you just don't because your language is not well enough edited, doesn't help you. So the court says, look, in order to fine for the employer, I would have to ignore the word or in the first line of this clause. If you were terminated for cause or, right? I'd have to ignore the fact that these are considered to be different things. I would have to ignore the word include in the second paragraph. And I cannot do that. Words have to be given a meaning. They have a meaning. It's the ordinary meaning of the language. We all use the language and we use it to convey information to one another. And that's the information that's being conveyed to the employee. And it's the employee that matters because the employee is not a sophisticated party understanding the law. We're not dealing with an inter-lawyer negotiation here. We're dealing with being very precise and explicit to the employee so they understand what the language will result in if they are terminated. So the fact that the contract purports to comply with the law, intends to comply with the law, makes no difference. Maximenko is a 2024 case, and strictly speaking, I'm talking about like recent cases, meaning in the last year. But I like this case because I can't tell you how many times I've had this situation. The employee is 21 years of service, 59 years old, specialized position. Their termination clause states the employer could terminate employment at any time. That's not the major part. By providing notice and or severance pay as may be required under the applicable legislation. Now, employers sometimes standardize a contract amongst jurisdictions. And because they can't say the Employment Standards Act, because in Alberta it's called something different, and in BC it's called something different, et cetera, they will often use something like a shorthand of applicable legislation to mean that law. Again, don't do that because that didn't have a good result here. But more importantly is the and or. Now, and this again is what I may describe, and I mean this very non-pejoratively, but layperson language. You know, we use and or in circumstances where we don't really mean they're alternatives. We really mean both, but we say and or anyway because it's kind of a convention where people don't really think about what it means. But and or does not mean and. It doesn't mean or. It means and or as alternatives. But notice and severance pay are not alternatives. Right? They're both required potentially. So as soon as you put and or language in there, you're done. And I've had this in so many cases of employers who will use that kind of language. So the court said and or ambiguous, too vague. I don't know what it means. Applicable legislation. What? Not specific enough. Notice it doesn't say employment standards legislation. It doesn't say what legislation. So the court says, I don't have to guess. The employee shouldn't have to guess. This clause is void. I'd always like to put one in where the employer wins something that's pretty clear. And this is Birch. This is a case in which the employee was terminated after 8.5 months, got given 4 weeks of pay, which was partly gratuitous because you can see this is an ESA only clause. And this clause is one where the employer was so careful. The employer says, you know what? I am going to draft this in such a way that I'm going to leave it entirely to the function of the ESA to figure out whether this person's entitled to anything or not. So they say the employment is terminated. If your employment is terminated with or without cause, you will be provided with only the minimum payments and entitlements, if any, owed to you under the ESA 2000, including but not limited to wages, vacation pay, minimum entitlements to blah, blah, blah. You understand and agree that in accordance with the ESA, there are circumstances in which you would have no entitlement to that list of things. So they're not purporting to exclude specifically. They're purporting to rely wholly on the ESA mechanism, and they're warning the employee that there are circumstances where there would be no money. And then they go on to say, you understand and agree that compliance with the minimum standards of the ESA satisfies any common law or contractual entitlement. So there's your contracting out of the common law. And the court, yay, we win one, says that clause is enforceable and not ambiguous. There's no reasonable interpretation that could be found that it violated the ESA. And that's not from a lack of trying by the employee's counsel, who said, well, the employee might not understand that with or without cause might mean that they would not get any money in certain circumstances. And the court again says, and it's fortunately sauce for the goose and sauce for the gander, your subjective understanding doesn't matter. What matters is reasonable interpretations. And is there a reasonable interpretation that could come out the way you want it to? And the court said, no, there isn't. The employee appealed. The Court of Appeal concurred with the motions judge, dismissed the appeal, which would have cost the employee a lot of money in legal fees paid to the other side. And the court also said, well, yes, there's a saving clause in this contract, but we don't even need to worry about that because even without it, the language is crystal clear that there's no wiggling out from the effects of the ESA. Two other interesting cases. I love this case because it just shows you that employers should never be jerks. This is a case in which the employee is terminated after 3 years from a senior position. Contract provides for 3 months, but for some reason, this employer decides they're going to be cute and give the guy 1 week. And the court says, well, she sues, and the court says, well, because you didn't comply with your contract, you can't rely on it now. So I'm going to award 9 months to this person, even though the contract might have been enforceable at 3 months, because you repudiated it by not following it when you terminated the employee. So again, don't be cute. When you have language, follow your language. And Taylor is an interesting and circuitous case in which an employee was laid off temporarily, recalled after 6 months, but wanted to be paid for the 6 months. So the employee decided to say they'd been terminated in order to get 6 months of damages, even though they were still working for the employer. Kind of a cute gambit. The contract, though, contained a temporary layoff clause. The employee argued, well, the termination clauses are void, so I'm not limited, and I have 6 months of damages, so I should get 6 months. The employer knew the termination clauses were void, but said, but there's a temporary layoff clause in this agreement. And the court said, yeah, there is, and that's not a termination. So it doesn't matter if the termination clauses are void or not, because a temporary layoff is not a termination. Again, creative lawyering that went south for the employee. So drafting an enforceable termination clause. I was tempted to put see a lawyer last, but I actually think see a lawyer should be first, because you can see that this is very kind of technical. And for those of you who don't write for a living, the way lawyers do, I think it's really instructive to have your language written for you, frankly. But that is obviously an open issue. Review your contracts regularly. Pay attention to case law. As you can see, case law is coming out all the time on these kinds of cases. Review annually to ensure compliance with your decisions. That does not mean redo your contracts and hand everybody a new contract. It just means know where you stand. Always comply strictly with the ESA. Don't provide less than ESA minimums. List notice, benefits, severance pay. List those things, because you don't want to be in a situation like that one unfortunate employer that forgot benefits and then failed for the lack of a word. Make sure you expressly exclude common law, but keep it simple. Simple language is best. You will not be entitled to further notice at common law. You don't need to ask for releases. You don't need to say it's in full satisfaction. Just say that, because simplicity makes it harder for those little words to be picked apart and weaknesses found. Don't over-define terms. There's a temptation to want to give a laundry list of causes. Don't do that, because Ontario just doesn't care about your laundry list of causes. Ontario only cares about willfulness as a way of excluding entitlement. And if you're going with an ESA clause only, it's not worth the ink you're doing it with. Just don't bother doing it. You are bound to make a mistake somewhere in that list, and it will be fatal. Be clear and grammatical. And this is something, with due respect to the younger generation, I feel able to say this because I had the most gruff grammar teacher you ever met in your life in the 7th grade. I mean, grammar matters. Placement of punctuation matters to the interpretation of a document. So make sure that you can only read a clause one way, because if it can be read in more than one way, it's ambiguous. Consider all compensation elements: salary, bonuses, commissions, benefits, not only salary. Don't forget RSP matching contributions, something near and dear to all employees' hearts, which get left out all the time. Don't bother with a saving clause. We will always comply with ESA. I mean, put it in if you want to, but it's not going to save anything. So you might as well save a line of type. And do, I think, consider having the same clause with or without termination, either because you always intend to pay or because you want to say this is going to be done in accordance with the ESA in the way that happened in Birch. When to update? If you are providing a new employment contract, you can't just hand it to people and say, sign this. You can say, I'll give you $50 to sign this. And as long as you actually pay the $50 and can show that you did, that may be binding consideration. But an employee can say, you can keep your $50. Thank you. I'm not going to sign. Perfectly fine. If you promote an employee, if you add a new form of compensation, they suddenly become eligible for a new line of bonus or options or whatever the case may be, that's fresh consideration. And you can require a new employment agreement for that. Ensure that your contract is signed before payment or the new job come into force, before the new compensation is implemented. I always say to clients, paperwork first, implementation after, always, always, always. Just as on hiring, paperwork first, job after. You can always terminate the existing contract on notice and then offer new terms. But employees often really don't like being terminated, and they can really have a morale problem if you do it in that way. Not really recommended, but legal. So strategies to avoid risk. Review your termination clauses for compliance. Revise language as you are doing your annual updating or your periodic updating to avoid contracting out. Make sure your template is up to date in terms of ESA compliance in other respects too, because employee counsel are creative, and they will try and find a way to use ESA breaches against you. So you want to avoid having any. Remove obsolete terms like non-competition for non-C-suite jobs. It's just pointless, and it gets people's back up. And, severance language ought to be enough to sever it off, but who knows in this day and age. So I wouldn't do it. Make sure you keep good records. When you update contracts, when you provide a letter saying, your existing contract will continue in force and effect, keep copies of all that stuff, because that's what, as a litigator, I need to defend you. Consider helping your employee mitigate if you're going to be sued. Give reference letters, give job search services, give them an ability to mitigate so that the damages that you're going to face if common law applies are less. And consider settling if your language is demonstrably bad, because if it is you've got to ask whether there's any point in your being one of the cases on this list that we reviewed today from a reputational standpoint. So those are my comments. Thank you very much for your attention.
Thanks very much, Allison. All right, so we're going to take a 10-minute break to stay on schedule. So we're all going to come back at 2:30. Okay, thank you.
Welcome back from your break. Now, I'm going to be talking about the planned reforms for the Ontario Superior Court system. Just a quick survey. How many people in the room here have received a lawsuit from an employee or former employee in the last 5 years? Okay, probably more than half. So this session might seem a bit like, maybe this doesn't really apply to me directly, but odds are if you're an employer in Ontario and you have more than, say, a dozen employees, there's a good chance in the next 5 years you will receive a lawsuit from at least a former employee. There's a lot of litigation out there. And in fact, in the years I've been doing this, I would say 15 years ago, when I would be consulted by a client about a termination, I would say maybe 10 to 15% of those employees would end up suing the employer. I would say it's closer to half now. Very common, unfortunately, for employers. And now also, another reality of the situation is that the court system is basically broken the way things are going now. From start to finish, I think we're looking at probably 3 years for most cases to work their way through the system. Along the way, if you have to deal with any motions during a lawsuit, that can delay things by up to a year. Just getting case conferences can be a challenge. The idea behind a case conference is that if you've hit a procedural snag in the lawsuit and the parties can't agree as to how things should be dealt with. The idea behind a case conference is you can get an informal meeting with a judge who has the power to issue some procedural orders arising out of the case conference. The idea was this would be an alternative to motions to get cases moving along. Quite often now, if you want a case conference, you go onto the website to get case conference dates. And more often than not, there are just none available. And there will be new dates issued at the beginning of a month, and they may not be for another 6 months. So the net result is that it's taking longer for cases to be heard. And also, part of the reality is that sometimes that delay can advantage employers, right? Sometimes it's, I think, an emotional impact that when someone's been fired, they're angry, they feel they've been wronged, they don't think they're going to find another job. A year later, they've gotten over the emotion, they found another job, they moved on with their life. So sometimes it can be a good thing for employers that these cases take a long time to be heard. But it can also be a negative thing for employers too. I mean, first of all, it can result in higher legal costs because as the case is hanging out there longer, there's more prep time sometimes for the lawyers to deal with the case, and the thing is just hanging out there longer. So of course it takes time off from and energy from your day. Also, just litigating the case can become more difficult. For example, you may have key witnesses who are your employees, but 3 years later are no longer your employees. They can be more difficult to find. Memories fade about events, so the evidence is less reliable, and evidence can be harder to locate. Documents may not have been preserved the way they should have been, and valuable evidence can be lost. As well, with the current discovery process we have, for most cases, there's examinations for discovery if you don't settle early, and that process can be used as a weapon quite often by plaintiff side employment lawyers. And the way they do it is by, and I've seen this happen where, they basically torture the employer representative with many questions and sometimes on trivial things, and with the goal to try to embarrass the company representative and put them on the defensive, and therefore try to pressure the company into acceding to their settlement demands. Now, I'm going to talk about reforms that are coming in a moment, but for now, I'll just quickly cover some of the more recent changes that have been made in the court system, some of which you might be aware of. First of all, we've got electronic filing of materials. It used to be that when you filed materials with the court, it was done in hard copy. And there were clerks or process servers who that was their business. They would take the material, collect the materials from the law firm's office, go to court, get a ticket, and wait in line to file the materials in person. Those days are over. Now everything gets filed electronically. And we have this system called Case Center, which is a horrible system that the courts have inflicted on us, where materials have to be uploaded that way. And now when we hear cases and motions, the judges don't have hard copies, which some judges are not happy about this, but they've been forced to adapt to the way things are done. So everything is on this Case Center system electronically, and so it's changed how we argue these cases as well. Like, we're not going through physical materials, but walking the judge through the materials online. As well, case conferences, pre-trials, most motions are now heard by Zoom. It's now only long motions, which are over in an hour and a half usually. They're still heard in person, although you can ask the court to hear those by Zoom, which is, I think, overall a good thing for everybody. It means less cost, less travel time, makes things more accessible for the parties. And there have been some new practice directions issued province-wide with the goal to trying to create more consistency in rules and procedures between the various judicial districts in Ontario. As some of you may be aware, Ontario is carved up into various judicial districts. And one of the challenges in our practice is that when we have cases outside Toronto, and we have a lot of cases outside Toronto, each judicial district has their own way of doing things. And sometimes it's set out in a regional practice direction, and sometimes it isn't. So that's, I really wish that they would change that if they were to make I think the best reform they could make for the court system in Ontario would be to bring in the same process and procedure across the province, but that doesn't look like it's going to happen. Okay, now I'm going to talk about these proposed reforms. Now, to understand a little bit about where we're going, I'll just recap where we've been on the court system and where we are today. When I started as a lawyer, examinations for discovery were basically wide open. There were no time limits. They could go on for days. Then the courts brought in 7 hours as a time limit, and now for what we call simplified rules cases, which are cases under $200,000, the maximum is 3 hours. So at least they've put some limits on that, and they've also limited the scope of documentary discovery. In the old days, it used to be that any document that had a semblance of relevancy, very broad, had to be disclosed. Now it's just relevancy, which has narrowed the scope, but there's still a lot of documents that can be covered by that. And the courts also brought in the simplified rules of procedure, which is currently where most employment cases are dealt with. These are cases with a claim value of under $200,000. And the main difference between the two processes is that with simplified rules, as I mentioned, discoveries have a limit of 3 hours per party. Regular cases at 7 hours. And regular cases have regular trials, whereas simplified rules cases have summary trials, where evidence goes in, first of all, by the parties through affidavits. And then in court, there are cross-examinations on the affidavits and then argument. And as well, some cases can be decided by motions for summary judgment. A big innovation with the court system for employment cases was the introduction of mandatory mediation. That is only in Toronto, Windsor, and Ottawa at present. But as I'll mention, discuss a little bit more later, that is proposed to be expanded to be for all cases across Ontario, all employment cases across Ontario. Now, mandatory mediation has probably been the most significant change for employment cases and how they're dealt with probably in the last 20 years. I would say 70% of employment cases settle at mandatory mediation. And it's also changed the dynamic of litigation, where these cases are brought by the plaintiff side lawyers with the full intent of settling at mediation, which can also make it more difficult to settle cases early because everyone is keeping their powder dry for the mediation. Okay, so now on to these proposed reforms. there's been what they've called a working group that it spent probably 2 years studying the current system and coming up with ideas for reforming it. And they eventually prepared a report, which was presented to the Attorney General and the Chief Justice of Ontario about probably 7-8 months ago now. And we don't know exactly when these reforms will be put into effect. The indications from the Attorney General are that they will be adopted and put into effect, but we don't know exactly when. From what I can tell, I would bet that 2027, sometime next year, is likely when they'll come into effect, because a lot of work will need to be done by the courts to get ready for this new system. So one of the important features of the new process is that there will be timelines mandated early on in the litigation process for how the case will proceed. And that will apparently be done at a case conference early on in the litigation. And if the timelines are not missed, apparently there will be penalties for missing these timelines. As those of you who may be aware, we've dealt with the litigation process. We don't have timelines right now. There's no set limit on how long it can take for a case to finish discoveries or be put down for trial, which means that if both sides decide not to push the case forward, it can hang out in the court files for years. And the new process will have what they're calling an upfront evidence model, which essentially will mean more documentary discovery and disclosure up front. Right. Whereas right now the case gets started and at some point, it might be 3 months later, 6 months later, maybe 9 months later, there are affidavits of documents exchanged. So under the new model, the documents will be disclosed earlier. And for most cases, there will be no examinations for discovery, which will be a welcome development probably for most employers. And there will also be more online fillable forms. For example, a statement of claim will now be called a notice of claim, and it will be filed online with a fillable form, as opposed to the way it's done now, where you just take this basic form that the courts have and you put in your claim, and it's the same with the defense. So there will be some greater uniformity in what these forms look like. With this proposed new system, there will be a 3-track model for how cases proceed. There'll be an application track, summary track, and trial track. And the track will be determined primarily by the value of the case, although the judges will have discretion to change the track if the case is particularly complex. So first of all, the application track. I see most employment cases will be falling under this track. The idea is that this is for cases that are fairly straightforward in that there are no major factual disputes. This could be for cases where the issue is maybe just what's the notice period and damages from the termination, for example, common law notice period, whether or not the termination clause is enforceable. There will be productions of documents required, but no examinations for discovery. The evidence will be put in through affidavits where there will be some limited cross-examination allowed, but not a lot. Mediation may be directed. And then the case is decided by a summary hearing, which will be similar to a motion for summary judgment, which we deal with now with Perhaps very limited oral evidence, but in most cases, probably none at all. Okay, then we have the summary track. This is for cases that are worth less than $500,000. Now, the small claims court limit has been increased to $50,000 recently. So now this could be for any case between $50,000 and $500,000, which is where most employment law cases fall, where there is some factual dispute involved. So this might be for cases where there are serious bad faith dismissal allegations where the facts are in dispute, just cause cases, and where there's a serious issue about mitigation. And in these cases, there will be, again, the upfront evidence model in place where documents get disclosed early on. Affidavits will be exchanged with cross-examinations happening out of court. There will be mediation required. And then the case, if it doesn't settle, goes to a summary hearing rather than a full trial. And the summary hearing would be similar to what we're having now in simplified rules cases, which is, as I said, most of the evidence goes in through affidavits with some cross-examination and then legal argument. Then there will be the trial track. This will be primarily for cases worth more than $500,000. And this will be more what we're used to in terms of cases. There'll still be the upfront discovery. There will be focused examinations, so some limited examinations for discovery, but focused on certain issues, depending on what the court directs at the outset of the case. There will be a scheduling conference to set timelines. There will also be mediation, and then there will be a trial management conference, which will be similar to what we deal with now with pretrial conferences, where a judge meets with the parties and goes through who the witnesses will be, what evidence will be called, and a timeline for getting ready for trial. And then the trial will be pretty much a regular conventional trial. Now, I attended a seminar recently presented by the judge who headed up the working group. And he was talking as well that for the standard case, the summary cases and the application track cases, that rights of appeal will be severely restricted, which will be interesting. There was a lot of consternation from the lawyers who were on that conference call. So I don't know if that's still going to happen, but that could be an interesting wrinkle for employers, because unlike, say, in commercial law cases, the law is the law in a commercial or civil case, right? Like not much changes from year to year. You could walk into a courtroom 30 years ago in the average commercial case, and the case law and the legal principles would be the same as they are today. But in an employment law, if you walked into an employment case 30 years ago, you wouldn't even recognize, what's going on. And if you brought them forward to the future now, their minds would be blown about how much has changed. So I don't know how that's going to work if they're going to restrict appeals, because we're always having a lot of legal developments in employment law. And if they're going to shut down appeals on the vast majority of employment cases, I think what we're going to have happen are a whole bunch of trial level cases that contradict each other in employment cases, which is just going to result in even more chaos for you and for us. So hopefully that doesn't happen, but we'll see. And by the way, with this new system, the idea is that there will be a lot fewer motions. That if there's I think the disputes won't be so much on discovery. There won't be examinations for discovery, so there won't be motions, which are often brought about whether or not a question was reasonably refused or not. But I think what we will still get are fights over whether or not documents should be disclosed, because we'll have the upfront discovery process where the employer, for example, is supposed to provide all the relevant documents. And, knowing what employers are like, they may not have all the documents produced up front. They're busy and they might be missing a lot of things. And I think the plaintiff lawyers are probably going to think, well, you're holding back a lot of documents. Whereas now, a lot of that gets dealt with in the discovery process, and the plaintiff lawyer can ask for documents to be produced. Well, now they're going to have to bring a motion saying, well, we didn't get all the emails. We think there are more emails dealing with this issue or the termination. So now I think what we're going to get are these motions that get dealt with in what we're going to be calling a directions conference. Whether or not at the end of the day this results in a more streamlined process is anybody's guess. Okay. All right. Well, we'll still be having mediations. As I mentioned, mediations are being expanded across Ontario. All right. So now pros and cons for employers if this new system goes into effect as is anticipated. I think there probably will be a reduction in legal costs and delay in each case. Certainly lower legal costs will be welcome for employers. Whether or not a case going along faster is what will be welcome for employers probably depends on who you ask. I think what we'll see, though, is more upfront time and costs in the lawsuit, because the early disclosure, early discovery of documents process is going to force employers to deal with the case up front. We're going to be nagging you for those documents up front, whereas we might nag you later on for the documents. We're going to have to be pushing for them very early on in the process. But it will also mean not spending a lot of time in discoveries or preparing for discoveries. And what in the past might have been a 2-week long trial will probably be a 2-day long trial. On the con side, though, I think we're going to see more claims. Just a little prediction there, because it's going to become, or the perception will be that it's a little bit cheaper to go to court and you can get to court faster, which I think will encourage litigation. And these online fillable forms, I think that will make it a little easier for your former employees to represent themselves and decide that they're going to just start their own lawsuit, which is going to make things more difficult, I think, in a lot of cases, for everybody to have more self-represented litigants who will also have their AI as their lawyer. And with the cases going along faster and with a more streamlined process, I think that's going to result in more cases actually going to court. But we shall see. Now, if none of this sounds particularly appealing to you, one thing to consider is using arbitration clauses in your employment offers and contracts, and avoiding the court system altogether. Now, you may not want to use this for every employee. This might be something you reserve for your more senior employees. But the advantage is that if you have and by the way, they have to be drafted in a way that they'll be enforced. So you can't take away people's rights to, say, statutory adjudication. So you can't take away someone's right to file, say, a Ministry of Labor claim under the Employment Standards Act. But if it's drafted properly, it's enforceable. And it means rather than going to court, the employee must apply for arbitration with a private arbitrator. And the advantage is that the system is way more streamlined. You get your arbitrator, you can tailor your discovery process as you like in exchange of documents with the arbitrator. it's not as formal, and you're not at the whims of the court system, not knowing when you might get called for, say, a motion to be heard or when the trial's going to happen. So the process is faster. And another, I think, big advantage is I think the quality of arbitrators out there for deciding employment cases is higher than the judges, right? Because the judges, most of them did not practice employment law, right? You might have family lawyers, criminal lawyers, commercial litigators. Most of them were not employment lawyers, and most of them handle all sorts of cases. Whereas you can pick an arbitrator who specializes in employment law. Most of them are also labor arbitrators. They know how to run a hearing, and they're very competent. They know their law. I think you're likely to get a more predictable result. And as well, the evidence ends up staying confidential. It stays within your process, right? There won't be a decision that ends up on the internet that anyone can Google and find out the dirty laundry within the company about your dispute. Now, the one downside is you have to pay for the arbitrator, right? And they're not entirely cheap. But I think when you compare the legal cost savings at the end of the day for a typical case, you'd probably end up saving money. So I believe that is my time. And we're now moving into the lightning round. Right, Jeremy?
We are.
Okay. So I'd ask our lightning people to come up to the front.
All right. So I believe first is Sarah.
Well, you know what? Yeah, but I'll go first.
You want to go first? All right.
Since I'm already up here, I'll just keep rolling. Okay. So we have in this round, we have 5 minutes per topic, or 6 minutes per topic. So this is going to go really fast. And if I'm talking too quickly, please forgive me.
You're getting no warnings, by the way.
Okay. So when are terminated employees entitled to bonuses? I'm going to be talking about cases where the employee is entitled to reasonable notice under the common law, which is either because they don't have a termination clause in their employment offer or contract, or as is often the case, unfortunately, the termination clause is not enforceable because, as Allison pointed out, it says and or something like that. So the courts have been very generous to employees, generally speaking, and have come up with a two-part test for deciding when an employee is entitled to have notice included in their damages for pay in lieu of notice under common law. Now, this is distinct from when an employee may have earned the bonus during their employment. So I'm talking about, okay, they've been terminated. The courts say if you're entitled to common law notice, then you get what compensation you would have received during the notice period. So this is post-termination. So the courts have come up with a two-part test. One, the bonus must be an integral component to their compensation. And two, it's not explicitly ousted under the language of the bonus plan, which is very difficult to find a bonus plan that, in the opinion of a court, ousts an entitlement to bonus. So now I'm just going to launch into two recent cases. One, Adelman and IBM Canada from this year, a few months ago. For whatever reason, IBM Canada has made a rich contribution to the case law on executive entitlements and wrongful dismissals. So we've got a long service employee, senior executive awarded a 24-month notice period. The bonus was not paid every year, and the bonus was not paid in the last year of employment, and was only, when awarded, worth about 16% of salary. And quite surprisingly, the judge did not award bonus to be included in pay in lieu. In the opinion of the judge, it was not an integral part of the employee's compensation because it wasn't awarded every year, and it was not a particularly high percentage even when it was awarded. I guess we have no slides, right? And then the other case it's a bit of a strange case. It's from BC, Gale and Fairmont Hot Springs Resort Limited, the Fairmont hotel chain. So this employee, 3.5 years service, 63 years of age, received a 9-month notice period. And the bonus plan had language saying that the bonus was awarded at the sole discretion of the employer. Now, in this case, the employee had ceased employment before the bonus for the prior fiscal year was awarded, right? And now a weird distinction in this case is that the bonuses were paid in 6-month increments. And it's a bit hard to understand exactly why the judge came to their conclusion. But net result was that the employee was awarded their bonus for the last 6 months of the notice period, of the prior year, because had they continued to work during the notice period, they would have received that bonus. So they got 6 months worth of bonus, but the employee did not receive any bonus beyond that because the judge said it wouldn't have been paid during the notice period. Now, the good thing about this case and the way the case law has gone on bonuses is it used to be that the courts would take what they called a prorated approach, where it didn't matter if the bonus would have been earned during the notice period. They just simply said, well, if it was worth like 20% of their salary, we'll just tack that on to pay in lieu of notice and give an extra 20%. Based on a Supreme Court case called Matthews, they're now saying that it has to fall within that notice period. So in other words, if I'm terminated today, but my notice period is 6 months, but I would only have earned a bonus had I been working for another 9 months, then I won't get it. But if my notice period is 12 months and the bonus would have been paid during that notice period, then I would get it.
Hi, everyone. So I'll be talking about bad faith damages. So interestingly, we're seeing an increasing trend of bad faith damage or bad faith allegations in wrongful dismissal claims. I note that bad faith damages claims are a mechanism through which settlements in wrongful dismissal actions can be characterized in tax advantageous ways. So that may be at least part of the reason for this increasing trend. So I looked at the case law for the past 10 years on bad faith damages, and there's been some pretty hefty awards. But don't fret, there also needs to be some pretty bad behavior to attract these sort of awards. So a 2017 case called Doyle at the Court of Appeal, there was a $60,000 bad faith damages award. The employer in this case pressured the abandonment of a harassment claim. They led only a very cursory investigation into the harassment claim itself, and they misrepresented to Doyle that the job was secure and that she would be given a chance to improve, when in fact this was not the case, and they were always planning on terminating her. A fairly famous case called Galea and Walmart, 2017, this had a $250,000 bad faith damages award. So again, there was dishonest and misleading rationale throughout the entire dismissal process. The employer also withheld entitlements. And what's interesting to me in this case is that the employer's litigation conduct was taken into account, which is actually a pretty rare consideration for the court to look at. So the employer's litigation conduct really worked to drag the case out in an unnecessary manner. They refused to provide timely disclosure and refused to conduct examinations for discovery. So all of this behavior together led to one of the biggest bad faith damages awards that we've seen. 2018, there was a case, Rustin and Keto, MFG. Now, in this case, it went to the Ontario Court of Appeal and was upheld. $25,000 were awarded for bad faith damages, where the employer made unfounded fraud allegations. They also had some intimidation tactics, again, in litigation. So they commenced a baseless counterclaim, and this was taken into account. The employer also said certain things at the time of dismissal that the court really did not look favorably upon, including saying things like, I mean, going through a lawsuit is going to be very stressful and costly. That the court did not appreciate. They also made a lot of personal attacks against the plaintiff, which, because they were unsubstantiated, led to the bad faith damages award. Moving on, Humphrey, this case was from 2021, upheld at the Court of Appeal. A $50,000 bad faith damages award was made for exaggerated and unsupported cause allegations, and also toxic treatment. So this is why it's important when you want to terminate an employee for cause to check with an employment lawyer and make sure that cause really does exist in the scenario. But here the employer went pretty far and made some pretty exaggerated claims of cause. Another case, McGraw and Southgate, which is a township case from 2021, led to a $75,000 bad faith damages award. Here, there were some very false and sexist rumors that were spread by the employer and representatives of the employer about Ms. McGraw. There was also a flawed investigation and a lot of discriminatory treatment. So again, one of the trends we're seeing is that the investigation needs to be done in good faith. Moving on to a 2022 Poland Hudson's Bay case, $45,000 were awarded in bad faith damages. The employer behaved in an unduly insensitive manner during the termination. So they walked out the employee, even though the employee had done nothing wrong and it was a without cause termination. This was considered to be unduly insensitive. They also delayed ESA payments. And there's an important distinction here. Sometimes payroll makes a mistake with respect to ESA entitlements, or sometimes an ROE is a little bit late. If it's a true administrative error that's caught and fixed, that is probably not going to lead to damages like this. Here, the employer was purposefully delaying the ESA payments, and they had a late and incorrect ROE. They also made a misleading offer. So basically, they demoted him, and the offer was designed to strip his minimum entitlements. All of this taken together, $45,000 of damages. Rutledge was a 2022 case. $50,000 were awarded for bad faith damages. Again, we see an improper and coercive workplace investigation. So there's a theme here with our investigations. They had appointed a non-independent investigator, and there was procedural unfairness found throughout the entire investigation. Just a few more left. 2023, Aurora Hotel Group, $15,000 were awarded in bad faith damages for an untruthful and misleading termination conduct. There was no written notice provided. ESA payments were yet again late. There were unfulfilled promises made to the employee. And again, a suggestion that the employee resign instead of being terminated. Big no-no. Finally, my last case, Strudwick, which is a 2016 case upheld at the Court of Appeal. $70,000 were awarded in bad faith damages. This was because of a campaign of abuse that the employee suffered. Together with a refusal to accommodate and some post-termination misconduct that led to this heightened award. This one was pretty egregious. The employee was confronted in front of about 13 of her colleagues. She was yelled at and called a goddamn fool. She was informed of her termination for misleading reasons. And when she wouldn't sign a release that was essentially designed to deprive her of legal rights, she was not given the money that the company owed her. So pretty bad behavior. And this led to a substantial $70,000 award. That's everything from me. Thank you.
Okay, hello everyone again. Funny seeing all of you here. Okay, so I'm going to be speaking briefly on notice period awards that have been awarded in Ontario over the last few years. So this is a bit of a tail end off of Allison's presentation, because if your termination provision is invalid, you're probably going to be required to pay some kind of common law notice. So in Ontario, we're certainly seeing a bit of a trend that is reasonable notice periods that are being awarded by judges tend to be getting longer. So the basic rule is still a very familiar one, and that is the Bardell factors. So Bardell was a case back in 1960, and the courts told us that we have to consider a few factors when determining how much common law notice an employee would be entitled to. Namely, an employee's age, we're going to look at their length of service, their character of employment, and the availability of comparable employment. So we're going to look at the job market. And traditionally, we often talk about a 24-month cap, which is described as the high end of the range that is usually reserved for longer service employees. But that is certainly not an absolute hard ceiling. So in exceptional cases, Ontario courts have certainly gone higher than those 24 months, particularly into the 26 and 30-month range, especially for older, long service employees with specialized or non-transferable skills. But the more interesting trend for employers, and in my opinion, is not just the long service employees, it's actually how much notice is being given to the short-term employees. So Ontario courts are showing that short service does definitely not mean short notice in all cases. So this is the part that employers really need to start paying attention to going forward in the coming years, because without well-drafted termination language, like Allison spoke about this morning or afternoon, employers can definitely be on the hook for many months of notice, even for an employee that's potentially in their probation period. So the old shortcut of 1 month per year of service, for instance, that's no longer a rule that we should take as a given. It's potentially dangerous if that's the assumption that we're going off of. So I've pulled some cases to try to illustrate this. So the first case is called Shelp versus Go Secure, and that's a 2025 case from the Superior Court in Ottawa. And in that case, Mr. Shelp, the plaintiff or the employee, was a vice president of sales. He had only been employed for 10 months, but the court ended up awarding him 6 months' notice. The court looked at his age. He was 51 years old, and he was making $190,000 a year. And he had a very specialized software sales background, and the fact that it took him about 11 months to find comparable work. So the message from Shelp is definitely that short tenure does not save the employer if the employee is senior or has very specialized skills or is finding it difficult to find comparable employment because of the overall job market. Another example, which Allison went over, was Chan versus NYX Capital. That's also a 2025 case coming out of Ontario. But essentially, Mr. Chan was terminated just before the end of his probationary period, specifically 1 day before he was going to get out of that 3-month probation period. The court found that the termination language in his contract was unenforceable and ended up awarding 3 months reasonable notice. So that's crazy to me. So the guy worked less than 3 months, but was awarded 3 months notice. So the reasoning was that his senior title, he had a specialized role, and specifically the court looked at the awkwardness of explaining such a short tenure. It would make comparable employment more difficult to find. And also important to note is that the court also invalidated the probationary period language. So the judge indicated that even though there was probationary language, it did not rebut the presumption that he was entitled to common law notice. Okay, and the final case that I wanted to go over is Smith versus Linderbrook Gulf. I believe this case was a 2024 case, and it came out of Oshawa Small Claims Court. So that employee only worked for 1 month, and the court awarded him 5 months reasonable notice. So that was probably the most egregious one. So why did he get so much is what I was asking myself when I was reading the case, or at least the summary of it. It was definitely obviously not his length of service, because that would not award him that much time. It had to do with all the other factors that worked in his favor. Specifically, he was 51 years old. He had about 15 years of experience as a golf superintendent and held a very specialized role. So he wasn't like a general laborer, who can pick up his shovel and go to another site. He was a golf superintendent. And the court accepted that these jobs are usually filled before the golf season starts. So the timing really mattered here because he was fired in June, which is mid-season. So at that point, comparable jobs in the golf industry had already been taken. So the court's reasoning was basically, yes, we acknowledge that he had only worked here for a month, but he was also in a very specialized seasonal role that he's not going to be able to fill until next season. So that case is a really great example of the trend that I wanted to illustrate, that short service does not automatically mean a short notice. So it's just something to consider when you're determining whether or not you want to terminate someone. Don't just think because they're a short service employee that you would have to give them a short notice period. Make sure that you're looking at all the factors surrounding that individual's employment. Okay.
Thanks, Natalie. So I'm here to talk about a topic that will matter to some folks and to some not at all. And of course, I'm very thankful to my partner, Landon, for giving this topic to me at the end of the day while everyone's waiting to go home. So the collective bargaining trends, what we've been seeing, obviously collective bargaining trends often track with economic realities. And as those economic realities change, we have different parties taking different tack at the bargaining table and different pressure points depending on the availability of labor, the availability of capital, and the forecast over the term of the collective agreement that is being negotiated for what might come in the future, as well as what has happened in the time the parties were locked into what is typically a 3-year deal based on the assumptions about what was going to happen over that term. So we've seen some macroeconomic indicators in Canada pointing to a transition from what was peak wage growth in the sort of post-COVID pandemic inflation surge time and a cooling of labor demand. And sort of the persistent sort of catch-up demands of employees have been not quite as substantial over the last year or two of bargaining. While union agreements do remain front-loaded, meaning that if you're going to have a sort of a 3-year deal and you're going to have a certain percentage over the duration of that deal, in each year of the agreement, you might have a different increase. Those increases tend to be weighted more heavily in the first or second year of the contract, as opposed to in the second or third year of the contract, to sort of help employees catch up a little more quickly to what's happened. We've seen overall sort of an encouraging, we've seen a little bit more of a conservative approach from employers. So although in the last, maybe a couple of years ago, outside of certain specific sectors like construction, where there were still some giveaways that I think probably were not market sustainable, in the majority of private sector negotiations, we've seen a cooling, and that in large part is because we were returning to a bit more of a sort of cost of living and inflation picture that was coming back to the Bank of Canada's target 2%, or in that range of 2 to 3%, which means you're much more likely to see normative gains as opposed to sort of a massive demand and pressure from labor. Our forecast for 2026, of course, for those tracking this, was between 2.3 and 2.5%. And the Bank of Canada was suggesting, at least at the end of last year, that it was expecting us to return to that sort of 2 to 2.5% range by the end of this year. Even below 2% were some of the forecasts from some of the banks. So a lot of employers that were negotiating were making those points at the table, explaining that they had just given large gains in the last round, and that now isn't the time for us to be, playing catch up. Now we're supposed to return to sort of normalcy. Of course, then came the war in Iran, and soon we have the renegotiation of what we call the CUSMA, the new NAFTA agreement, and we're seeing inflation spike. So we saw it go from 2.4 to 2.8% just in the month of April alone. And that was not expected. And the Bank of Canada, of course, decided to hold its benchmark rate, but they're sort of softening their message about whether there might be increases in the near term before the end of the year, even though they originally said that we'd be waiting for that. So what are we seeing? We're seeing a lot of parties that are unable to get 3-year deals, where it's permissible to have a shorter deal than 3 years. And that's because parties are dealing with the uncertainty. They're unwilling to force themselves to be strictly confined to a contract that's based on an economic picture that is unknowable. And a lot of companies are unsure about their own plans for the future. What will happen with layoffs? What will happen with restructuring? It's very difficult to forecast what your labor needs are going to be and what you can afford 3 years from now, when month by month, it seems we have a new reason to wonder what the economic picture will be. First contracts have been taking an awful long time, a year or more in most cases, to be negotiated. We're still seeing those front-loaded increases that I mentioned. We're still looking at cost of living clauses being negotiated fairly strenuously, although tagged to inflation, which again is not quite as knowable. In the last year or two, we saw a lot more strike activity. It's actually above pre-pandemic levels, which is interesting. Not sure exactly what's driving that, but it does mean that labor is more willing to not just give a mandate to the union to press their bargaining rights by saying, hey, we have this strong mandate, so you should listen to us and give us what we've asked for. That they've now shown that the members are willing to take to the picket line and go on strike. So that puts more real pressure on management if they don't want to take a strike. Tentative agreements have been rejected. So a tentative agreement is where the parties at the table, the committees, so the union and the employer, agree on the memorandum of agreement, and then the union goes back and tries to convince the members to ratify the deal. We're seeing more and more that the employees are unwilling to ratify, even where the union has agreed that they will promote or they will recommend that the employees vote in favor, as opposed to just putting it to a vote and remaining silent. We're seeing a lot more hybrid work clauses. We had a great presentation today about hybrid work, and we're seeing a lot more in basically in any sector where hybrid work, or any position where hybrid work is possible. We're seeing that come up at the bargaining table more and more. And we're also seeing some indications, at least I have in my practice, questions about technological change, AI in particular. Those sorts of clauses tended to be in industrial collective agreement negotiations more commonly, right? Where new technology would mean automation and the removal of jobs and things like that. But we're seeing these sorts of issues much more coming to the fore for white collar workers. 3 quick points on, some specific areas. Public sector specific, some of you might remember if you're in public sector or quasi-public sector, or if you're a taxpayer and you care. Bill 124 in 2019 imposed 1% per year maxes on the increases that could be applied to wages in public sector employers, and unions all challenged these, went all the way, basically everywhere. There were challenges to this. As a result of the widespread union movement on this, most employers in the public sector agreed to something called a wage reopener clause, or they sort of negotiated on what they would have agreed had the cap not been there. So ultimately what ended up happening is, when the courts declared the bill unconstitutional, the parties all had to go back to the table in these wage reopener clauses and sort of bargain over what they would have done had the law not been there. Those have mostly sort of completed working their way through the system, although a lot of public sector bargains in arrears. So sometimes it's a year or two that you should have been negotiating, and so you're by the time you're bargaining, the agreement you're renewing is already expiring. It's very confusing, but so that there's some of that going on. But generally, that's all lagged a little bit, the inflationary surge that came through COVID as a result of this. So it's made public sector bargaining a little bit confusing for some, where inflation wasn't baked in, especially with the pressures we're seeing now. Under the Canada Labour Code, there was a replacement worker amendment, which came into force, banning replacement workers during strikes and lockouts. Now, in most provinces, replacement workers during a lawful strike lockout situation are lawful. And under the Canada Labour Code now, it's completely banned. I will say there are some limited exceptions: health, safety, property protection, certain local excluded employees under certain in certain industries, but those are usually essential services workers who often can't strike or be locked out anyways. So those exceptions aren't quite what they appear to be. The implications here, obviously, is that this is greater union leverage, right? If the union can threaten a strike, get a strong strike mandate, and take the workers out on strike, the employer may not be able to deliver the services, and they can't try to limp on during at least a short period to keep services running. And finally, gig workers. So in BC, they amended explicitly their Labor Relations Act to provide that sort of gig workers could unionize. And so as a result, the UFCW was certified and has now, as of April 28, 2026, they recently, 1,000 Uber workers are now represented and have a collective agreement in BC with the UFCW, which is one of the first gig worker collective agreements to be ratified in Canada. Contrast to the experience in Ontario, we have no explicit rule for gig workers. What we have is the standard rule for who is an employee, which is either direct employment or someone that's classified as a dependent contractor. There have been numerous cases regarding everything from taxi drivers to other kinds of sort of pre-gig worker. We did have a case in 2020 where the Foodora employees at the workers at Foodora, I won't call them employees, I suppose, were found to have been employees within the meaning of the Labor Relations Act. And so they won their right to unionize. And then the company shut down operations within about a month. So that was the experience we had. I think seeing the pattern and the likely result, what happened with Uber here in Ontario is rather than go to war on this subject, Uber just entered into sort of consensual bargaining with UFCW. The Postal Workers Union tried to bring an application alleging that bargain was somehow not covered by the Act and couldn't be sustained. And that case, as far as I know, it went nowhere. I don't know if it was officially dismissed, but it doesn't appear to have gone anywhere. It's been a while. So what we've got is a collective agreement between, or some kind of agreement, whether it's truly a collective agreement or not, between UFCW and Uber here in Ontario, governing the workers who are driving you around and delivering your goods. So those are my comments on collective bargaining trends. So now I'll invite basically the entire cast to join me up on stage. For Q&A. And so for those of you here in person, if you've got I think it's the green sheets are for the Q&A sessions this afternoon, and Rita will circulate. Thanks, Rita, to pick those up. In the meantime, let me just see if we have some questions that have come in online. Jeff,
Yes.
I've got a good question for you.
Okay.
Are you allowed to request drug and alcohol testing if the employee appears impaired at work and they're in a safety sensitive position, but we don't have a policy? And if we are allowed to require testing, what would the appropriate testing be?
So generally, there are three types of drug and alcohol testing. One is pre-employment or pre-site access. The other is for cause. There's a reason why you think somebody is impaired and you want to test them. So pre-access, for cause. What's the other one? No? Kind of drawing a blank. Anyways, your example.
Post-accident near miss.
Yeah, sorry. Thank you. Post-accident near miss. So in your situation, it seems as though there is cause to require someone to submit to a drug and alcohol test, and therefore that is permissible. Technically, you don't need a policy to do that. It's strongly recommended that you do have a policy to do that. The type of test you want, you want to screen them for alcohol and sort of the standard panoply of drugs. that the person may be affected by. But understand this, the tests, primarily the drug tests, do not prove impairment. They simply prove that the individual has a substance in their system. So it's certainly corroboratory, is it? Corroborative. Sorry, we're towards the end of the day, and I'm completely sober.
We didn't get our cookies. we didn't get our cookies today.
Yeah, I didn't get my cookies. So it corroborates the fact that this person might be impaired because they have an insane amount of cocaine in their system, but it doesn't prove it. And so, question whether you actually need to have a test then at that point. If the individual is showing signs of impairment and isn't fit to work, obviously you're going to send them home, and you may consider whether that's good enough evidence to take a disciplinary response to whatever it is that you believe to be improper about the person being impaired at work, of which I spent half an hour talking about and explaining that it's bad.
Thanks, Jeff. Anyone have any questions that have come in from in person? Landon, you want to?
So the question is, are employers able to contract out of paying bonuses to terminated employees with language like the employee must be employed at the time of payout, unquote? First of all, the courts have said, yes, it is possible to have a bonus plan or contract that excludes that excludes bonus from pay in lieu of notice under the common law. But the language must be concise and specific. This was stated by the Supreme Court in that case I mentioned, Matthews and Ocean Nutrition. And there have been some cases since then dealing with it. The takeaway is that the language must be painfully, excruciatingly specific and clear to oust bonus from being included in common law notice. This kind of language, quote, the employee must be employed at the time of payout, is not sufficient. And the court's reasoning, and this also goes back to cases dealing with stock options and whether they should be included in pay in lieu of notice, is that but for the termination, the employee would have been employed at the time of the payout. Meaning that, like, the way that courts look at it is if the employee is entitled to reasonable notice of termination, then that's what the employer should be doing, which is very artificial because very few, for obvious business reasons, employers do not give reasonable working notice of termination to employees. So that just doesn't happen in the real world. But the courts in their ivory towers have decided, or the judges in their ivory towers have decided, no, they should get whatever the language would give them had they continued to be working. So you need to go beyond that. Even saying you must be actively employed at the time that bonus is given is not enough. Now, if you have language that goes a step beyond and talks about you're not entitled to it as part of common law notice or something like that, then you might have a fighting chance. But I'm not going to draft that language here before everybody because it's very tricky and you need to think about a lot of different things. And all I can say is if you have a bonus plan and you want to have a fighting chance of carving it out of common law notice, you should get legal advice on that point. And your lawyer will need to think long and hard about what kind of language would potentially give you a good argument to exclude it.
I'd probably add to that, Landon, that it's important that the exclusion isn't just in the terms of the bonus plan, that it has to actually be incorporated with the individual contract of employment.
Yeah, I mean, it depends on the specific situation. Right. But sometimes practically what you might have is an employment contract that might have an ESA only termination clause that a court has decided is not enforceable. And then, like it or not, comes down to the bonus plan. So
Allison, I see you have a question from the crowd.
Yes. I noticed many clauses use severance pay. Do they mean better? Am I on? Okay, sorry. I noticed many clauses use severance pay in quotes. Do they mean termination pay in quotes, bracket, common law pay in lieu of notice? Severance pay meaning a large number of employees terminated. So I think we need to go back to first principles here. The clauses that I was talking about are by and large employment standards minimum only clauses, with the exception of the one that said, oh, and you get another week, right? By and large, they're limited to employment standards minimums. Those minimums consist of termination pay, which is between 1 and 8 weeks of pay or of notice or pay in lieu, and statutory severance pay. And statutory severance pay is a week per year of service to a maximum of 26 weeks for employees who have more than 5 years of service and work for employers whose payrolls are more than $2.5 million. So those people get severance pay irrespective of whether a large number of employees are being terminated. That large number of employees part is coming from the mass termination provisions of the Act. But that's not the only time when severance pay is payable. So the severance pay that's being referred to in these termination clauses is statutory severance pay, and it's a different thing from termination pay. That statutory severance pay has nothing to do with common law notice. Now, it's true that when we talk about a severance package, we mean the whole financial package. That's a different use of the word severance, just to be complicating of things. Maybe it's better to call it a separation package, but people call it severance packages anyway. But that's a different use of the word severance. So the clauses are talking about statutory severance pay, and that applies quite broadly if you have a payroll of 2.5 million or more. And frankly, with inflation, more and more employers are falling into that category by definition than would have applied, say, 30 years ago. And that just accrues when you hit 5 years of service.
So I've got one more question here for you, Allison, that I think sort of flows well. It's actually two questions. I'm going to combine them. There's a question about whether it's recommended at one point, I guess, in the discourse, to have just without cause clauses and not mention with cause at all. And what if we just follow the Birch decision and use the with or without cause in a single paragraph? Is that something you think is a good idea? Sort of just throw out the baby and the bathwater and start anew?
Well, I've seen variations of this. The Birch clause is a clause that says, maybe you get nothing, but we don't have to decide that right now. We're just going to let the Act decide that. And because you rely on the Act language, you can't violate the Act. The other variation of that is to say, you know what? We don't care if you burn our building down. We're still going to give you statutory notice and severance pay. In other words, whether that's cause, that's willful misconduct, right? But we don't care. We're going to pay you that either way because we just don't want to bother sorting all of this stuff out. So it depends which, like choose your poison, I suppose you might say. In terms of my own preferences, I mean, you could say, what if you're just silent on cause? Does that mean that you can't rely on it in the appropriate circumstances? So if somebody did burn your building down, you'd be bound to pay them? I would not say that was the case. If you have a clause that says, if I terminate you without cause, I do this, and you say nothing about cause and nothing about willful misconduct, and someone burns your building down, I would still fire them on the basis of willful misconduct and pay them nothing. So there are different ways of approaching the problem. The question is, in a way, how much certainty do you feel you need to have? And how much are you prepared to just throw money at at the problem, throw money at everybody at the minimum standard, just in order to avoid any of these kinds of complications. And there's no right answer to that question because these are all different iterations that you could choose from.
Okay, can I just add on to that?
Sure.
So in the Birch case, they didn't need that with or without cause language in there. And I think that was part of the reason the plaintiff was arguing there was ambiguity in the clause. In the end, the court found there wasn't. But they could have just not included it and probably not even had that plaintiff argument and probably not could have spared themselves a trip to the Court of Appeal. They won, but it still costs them money, no doubt. If I think the bottom line, if you have an ESA only termination clause, you don't need to mention cause, right?
It's helpful if you say these entitlements, if any. And by putting in language like, if any, you're leaving open the possibility that there aren't any.
Right. Because under the ESA, if you have an employee who steals or vandalizes, whatever, if it's willful misconduct, they don't get termination pay or severance pay. So you don't actually need to say if there's cause or not cause. Like it's a foreign concept under the ESA. So if it's ESA only, don't mention cause. The only time I would bring up cause is if you have a clause that gives more than ESA, right? So let's say if you have a clause that says if there's without cause, you get 3 weeks per year of base salary or something. And if there's with cause, you're going to be limited to the ESA, like something like that, right?
That's certainly an option. So the question comes down to as well, the more words there are, the more opportunities there are to attack your words. So in this particular case, the Birch result, I think, was the right result. But Landon's quite right that in theory, having with or without cause in there was a reinforcement of a concept that was already built into the rest of the language. So,
yeah, I mean, with termination clauses, less is more. And there have been plenty of times where we've had like, here's our termination clause we give to our client. And then 5 years later, we get the demand letter, they send it to us, and the client added language.
Yeah, don't.
And they were, well, why'd you do that? Oh, well, we made it stronger. We made it better. It's like, well, you also made it unenforceable.
Yeah.
Less is more with termination clauses.
Jeff, I think this question's been submitted because they wanted to see me try to say the name of the person in this case. I'm going to stumble. It's for the Jasilski case. Why wasn't the employer required to investigate whether or not there was an addiction that contributed to the 4-beer lunch and subsequent drunk driving?
So this is an interesting question. And what struck me about this case, I didn't even mention because it wasn't relevant to the topic, but the employee in that case was represented. And when I see a case, I always try to see who the counsel were that argued it, just out of interest. So I did that. And Mr. Jasilski was represented by a commercial lawyer. And the commercial lawyer brought forward 2 claims: wrongful dismissal and for the oppression remedy under the Business Corporations Act. Now, what's the oppression remedy under the Business Corporations Act? I'm not an expert on the Business Corporations Act, but it basically means that you dissolve the corporation because you believe that it's ungovernable. That's a very crass way to put it, but that's basically what it is. So this commercial lawyer thought that, well, I asked for the oppression remedy in another case, so I'm going to do it here just to add pressure to the other side. Got quickly dismissed, but the short answer to the question is the Human Rights Code wasn't even referenced. And so the issue of whether the employer needed to investigate and to ask whether the person had a disability was simply never litigated, and the court never had to decide it because the counsel likely didn't even think of it. Which is why I picked that case, because it's a good way to sort of segregate out the whole human rights overlay and just look at the pure common law principles.
Wasn't just for the pronunciation challenge of the plaintiffs. plaintiff's name. That's good.
And it is, after all, quite possible for someone to drink 4 beers at lunch without being an alcoholic.
But that would have required
that
would have required the lawyer to sit down with the person and say, "Okay, well, what happened?" No, you're not an alcoholic. You just like 4 beers at lunch, right? It seems like negligence on my part.
Well, they probably did the intake at lunch somewhere with a few beers.
Yeah.
All right. So, Allison, a question for you here. So, if you've got an employee on a contract, presumably this is implicitly a term contract, and you want to extend it, do you need to offer fresh consideration for the contract extension?
That would depend on whether there's a provision in the contract that already allows for it to be extended by mutual agreement. So if you have a provision in your existing contract that says the parties can extend this agreement in writing, signed by both of them, then you're extending within the terms of the contract. Therefore, you don't need fresh consideration. If, on the other hand, you don't have that and you're just offering a new term agreement, then the consideration is still the work, because the contract, the work comes to an end under the old contract. You offer the new contract, the consideration is the work. Otherwise, it wouldn't be given. So does that mean you don't give financial consideration just in case? Sure, it doesn't hurt to throw in $10 as consideration, but you don't need to, because it's the work that's the consideration in that scenario.
So, Landon, we're going to get you to sort of expound a little bit about what you see coming down the pipe in changes. Are you aware of, or do you foresee or predict any sort of new regulations or court procedures restricting the use of AI in civil litigation generally, given the number of cases where there have been, wastes of court's time, fake case law, things of that nature?
Well, I mean, right now, when we file legal briefs like factums with legal argument, we have to certify that these cases are real and not the product of AI hallucination. In terms of whether there's going to be whether like specific changes to the court rules, I don't know, and I don't think the courts know, because it's a big question mark as to where we're going with AI. And one thing we know about the courts is they don't react quickly to changes. And so ask me in 5 years when society has been radically transformed by AI, maybe then the court, there'll be like a discussion group or a working group at the courts to discuss how we're going to adapt the court system to deal with it. But as of right now, I have no idea what questions, answer the questions.
All right, a little bit less esoteric question for Jeff. So if someone is in a safety sensitive position and they've provided the employer medical evidence of an alleged addiction, and it's the employer's view that they can't be accommodated in their position, without risking people's lives. Is that the point of undue hardship, or is there any other accommodation obligation they have to explore?
So I'm going to just accept the premise that it's a safety sensitive position and the employer has concluded that they can't have somebody with this condition working for it. The problem with that is, of course, people go to treatment all the time. People stay sober all the time. And so the cases out there really don't endorse the principle that it's simply undue hardship for someone to have an addiction to work in this position. The undue hardship analysis is more based on, well, the person hasn't gone to rehab. The person hasn't agreed to consent to random testing. The person hasn't been honest with the employer. And so there's no precedent I'm aware of that simply says, if you're addicted, you can't do a particular job. The law contemplates second chances and has a fair amount of comfort on the guardrails I talked about to effectively manage these situations.
Sort of a follow-up to a question you received earlier, Jeff. So when effectively what they're asking is, when does the duty to inquire get triggered? So you've heard rumors from employees, but none of your managerial staff have witnessed a worker seeming to be unfit at work. Is sort of the rumor mill sufficient to trigger the duty to make an inquiry as to whether the worker is fit for duty or whether they have an addiction?
So I reject the premise of the question.
I like that.
Yeah, I reject that. I don't think it's a question of, are we legally required to do it at this point? I think that if you are hearing, and particularly if it's a safety sensitive job, if you are hearing that somebody is behaving in a way that raises a concern, go ahead and ask. You should ask. And there is nothing unlawful with asking. To sit the person down and say, look, we have heard reports of X, Y, and Z. And so right now we are asking, do you have a problem with drugs? Do you have a problem with alcohol? And if you do, we'll deal with it. So that's point one. I will answer the question, though, that I don't think the employer will be found to have not complied with the duty to accommodate, the duty to inquire, simply because it didn't put a lot of shred into hearsay, rumors, and innuendo. I think there has to be more. There should be observation to ground it. Further caveat, though, if supervisors have seen this, then the CEO has been deemed to see it. Management is, the first line of management is deemed to be enough for the corporation. In most cases, our clients are corporations to have effective knowledge of the situation.
We've got an awful lot of questions that have been answered now in different form. There was a question that came in, and Jeff, I'm not sure if you recall making this comment during the course of your original remarks, but there's a question here. Can you give us some examples of the hard questions you would ask in regard to fitness for duty?
Okay, so it's really not a question about fitness for duty, but it's a question about addiction. So I laid into the big general one, which is, do you have an addiction to drugs or alcohol? Do you use drugs or alcohol? Questions like further, when do you use drugs and alcohol? Have you ever used drugs and alcohol at work? Have you spoken to your doctor about this? Have you spoken to anyone about this? What is it about your drinking that is causing you not to come to work? What is it about your drug use that caused you to steal the apples from the apple cart? Why do you say that you stealing the apples from the apple cart have anything to do with the fact that you were drinking the night before? When's the last time you went to rehab? Are you engaged in an aftercare plan? Do you have a sponsor? Are you prepared to engage in random drug and alcohol testing? These don't have to be, like, there's not a limited number of questions you can ask. I would recommend even asking remote but probing questions, because nothing prevents you from doing it. And it's only to your favor, to your benefit, and likely to the benefit of the person you're talking to.
Okay. Well, thank you, Jeff. And thank you to all of our distinguished panel. The conference has now concluded. Thank you for coming in person. Thank you to all of you who joined us online. Just a reminder to all of you who joined us online, and for those who are here in person, if you would like to receive a certificate for your HRPA CPD recertification points, please send an email to events@stringerllp.com. There should be an email in your inboxes with a button that says download slides and materials now. So you should be able to see that and receive those and share those with your colleagues. And soon after the conference is over, for those attending online, you'll receive an email from SurveyMonkey asking some very short questions. It takes about a minute to answer the survey, just to give us the feedback we need to make our program better. And finally, again, just on behalf of all of us, thank you very much for joining us and making this a wonderful conference. Take care.